Members, the verification reflects 75 ayes, 68 nays. The amendment is adopted. Does any member wish to speak on, for, or against the bill? Mr. Huberty, for what purpose?
Waiting for the member.
The chair recognizes Mr. Wu to close on the bill.
Yield for questions.
The gentleman yields for questions.
Mr. Speaker, or Mr. Wu, I apologize as we go through this bill, and for me being here a while, this is a part of the session. I think we're all talking and whatnot, and sometimes not paying attention to what's going on. So your bill, how many different things are able to be done within management districts? There's a list of at least 30 or 40.
Several.
And I noticed one that you can provide money to a marina. Is that right?
Dozens and dozens and dozens.
Mm-hmm. And sewer systems and things of that nature, right?
Correct.
Okay. And we merely said public education facilities. Is that right? So you were saying you would like to add public education facilities. So let's assume for a second you have a school district, perhaps that might reside in a particular area that maybe is a Title I campus and doesn't have the ability to provide jerseys for their kids, or maybe there's low resources.
And in fact, that's actually one of the reasons why I'm carrying the bill, is because schools in my district, from HISD, because of the financial strain that HISD has been under, they're not able to provide some bus routes. They're not able to pay for jerseys for their soccer team. They're not able to get computers for the computer lab. They're not able to do any number of things that we would love to have because they're in a poor school.
Right. So my point, to get to cut to it really quick, is that as we were going through this, we were allowing a multitude of different things that these districts can provide. I happen to live in MUDs. I don't have any management district, but the MUDs, which provide the water, provide a lot of money to our schools to help our schools with trails and things of that nature. That's
Correct.
allowed under current statute.
Correct.
Correct, right? Okay. However, as a result of the amendment that Mr. Middleton just put on, what schools are allowed to now get money except public schools?
Only private schools.
So what we voted for in that was basically to say, we're giving money to schools, but only to private schools.
That's
We're
correct.
not going to help our public schools. Is that correct?
We took a record vote to give more money to private schools.
Okay, I want to make sure everybody understands what they vote for. So tomorrow on third reading, maybe we can sit and talk about maybe having a revisit the discussion, because I think the intent of what you're trying to accomplish is we're saying, hey, if the management district, wherever, and there's multitudes of these across the state of Texas, decides they want to help their schools right now, if they have a marina, they can help a marina, which is for profit, right?
Yep.
As we go forward. So thank you for clarifying that
Yep.
as we go forward. Appreciate it.
So just a few things that our school districts were looking forward to with this district, or with this amendment, or with this bill. School jerseys that the schools have been asking for, jungle gyms, preschools, daycare centers in old abandoned strip malls, and building repairs, just general building repairs that the schools need but they can't pay for. We were looking forward to these things. Wi-Fi, and any number of things. Move passage.
The question occurs on passing of resolution HB 2261. A record vote has been requested by Mr. Biederman. The clerk will ring the bell. Show Ms. Hinojosa voting no. Show Mr. Schaefer voting nay. Show Mr. Lozano voting aye. All members voting. All members voting. There being 78 ayes, 62 nays, HB 2261 is passed the third reading. Mr. Kaysen, for what purpose?
Mr. Speaker, I'd like to move that all remarks on 2261 and the amendment be reduced to writing and printed in the journal.
Members, you heard the motion. The objection, chair hears none. So ordered. Members, the next bill on the calendar is HB 2044. The Senate companion is over and eligible. The chair lays out on second reading SB 726. The clerk will read the bill.
SB 726 by Schwertner, relating to establishing actual progress for the purposes of determining the rights to repurchase real property from a condemning entity.
The chair recognizes Mr. Lamond to explain the bill.
Thank you, Mr. Speaker. Members, I would like to thank all of the stakeholders for working with me on this bill and for their support. Senate Bill 726 ensures that an entity using eminent domain follows through and constructs the project for which they used eminent domain. Specifically, this bill prevents an entity from acquiring property through eminent domain, simply having architectural drawings made along with acquiring an additional property and being able to hold on to those two properties indefinitely. Mr. Speaker, I have an amendment.
The following amendment, the clerk will read the amendment.
Amendment by Lamont.
The chair recognizes Mr. Lamond to explain the amendment.
Thank you, Mr. Speaker. This amendment addresses technology not contemplated under current law to show actual progress is being made. It would require a reclamation bond, which is a common practice to protect taxpayers and landowners. It would also ensure an infrastructure project of this magnitude goes from somewhere to somewhere and not just nowhere to nowhere, like they have done in California. Members, specifically, this amendment protects private property rights by any proposed high-speed rail project in Texas as it relates to the definition of actual progress. I move adoption.
Mr. Turner, for what purpose?
Mr. Speaker, would the gentleman yield for a question?
Or the gentleman yield for questions?
Yes,
The
certainly.
gentleman yields.
Thank you, Representative. I'm sorry, I just caught your amendment as you were laying it out there. What are you doing with this amendment exactly?
So the amendment includes the technology with respect to high-speed rail as
The
it
bill or
relates
the amendment?
to the amendment includes the technology of high-speed rail, which is not currently contemplated in the law.
Okay, so what is the purpose of the amendment?
The purpose of the amendment is to include the technology that's not currently contemplated. In the 80s, the legislature created the Texas High-Speed Rail Authority, which was a state agency authorized to regulate the use of eminent domain, among other things. After that last project did not materialize, that law was repealed, that state agency was dissolved, and the responsibilities of overseeing the use of eminent domain as it relates to high-speed rail no longer existed with respect to a state agency, and therefore a void exists today. This bill simply tries to put common sense bumpers on the side of this type of infrastructure to make sure we protect landowners and private property rights.
So with this amendment, basically, you're trying to put into statute that you can't, that this envisioned high-speed rail project cannot be constructed. Is that essentially what you're trying to do with this?
No, sir, absolutely not. That is not what this amendment does at all. This amendment treats high-speed rail very similarly to any other entity that uses eminent domain. You see, as the amendment is outlined there, what we're doing is making sure that landowners have the right to repurchase their property as it relates to high-speed rail infrastructure after 10 years if no project materializes, just like any other infrastructure project, but has some specific hurdles here that are important as it relates to high-speed rail.
Okay, so when you say at 10 years, if nothing's been constructed, how do you determine, what is the criteria for determining whether or not they could go and repurchase their property?
So
Like,
if they don't meet the definition of actual progress, which is a concept currently in law for other projects, if they don't meet that, satisfy the definition of actual progress, then the landowners that where eminent domain was used, those landowners have the right to repurchase that land, just like they would if it was a transmission line or or some other project that used eminent domain.
Okay, and how is progress defined?
What's right in the, as it relates to the amendment with respect to
Yes.
high-speed rail? So there are 5, as it relates to the amendment, you'll see under B2, Section 1, it says completing 3 or more of the actions listed in subsection B. Subsection B outlines 5 items that 3 of which have to be achieved. Then separate from that, item number 2 includes a 30-year reclamation bond that they would have to do as determined by the Attorney General to be sufficient to restore any affected property to the property's original condition if the property fails. Reclamation bonds are common practice in major infrastructure industry. And so that is the second item. The third item is completing construction of at least 50% of the project route. You see, I don't think any of us wants this project to turn into the California high-speed rail project that has been such a disaster. They've constructed and modified their plans to construct a project that goes from nowhere to nowhere. And what this requires is that they would have to, within 10 years, complete the project from a terminus to another rail facility or a passenger loading station that is not a terminus, which they currently have in their plans, to make sure that we end up, after a 10-year period, with a rail, a high-speed rail facility that goes from somewhere to somewhere.
Okay, thank you. Mr. Speaker.
Mr. Turner, for what purpose?
I raise a point of order against further consideration of this amendment under Rule 11, Section 2.
Please bring your point of
And
order.
Rule 11, Section 3.
Yeah, please bring both of them down front.
The point of order has been withdrawn. The chair recognizes Representative Lamont to continue explaining his amendment.
Thank you, Mr. Speaker.
Mr. Speaker.
Mr. Canales, for what purpose?
Gentleman yield for some questions.
Will the gentleman yield for questions?
I would like to finish laying out the amendment.
Go ahead, Mr. Lamont, with all due.
Be happy to yield to you, Mr. Canales, after that. So, in order to consider this amendment, it's important to understand the surrounding circumstances. The company proposing to construct a high-speed rail project in Texas has a significant history of not following through with commitments and misleading public elected officials. We certainly cannot rely on them to treat our landowners fairly. Real quickly, they promised no public funds, and now they want taxpayer money. They are aggressively pursuing taxpayer funds and loans to construct this project. The cost estimate was advertised as $10 billion. Now it's being advertised as $30 billion. They promised it was $10 billion, but now it's $30 billion. They promised right here in these halls not to close on any option contracts under oath, testifying in a hearing. However, until they get fully funded and they have all permits in place. As we stand here today, they have broken that promise. They have closed on those contracts and did not honor that commitment. They have misled Texans about this being a Texas project. We have found out it is not a Texas project. It is a project being put on and put forth by the country of Japan. They have been the primary funder for this project through an entity they set up in the Cayman Islands, and they hold the deeds of trust to the land that they have executed these contracts on. The technology and the financing is Japanese. The construction is with an Italian company, and a Spanish company has been contracted to run its operations. So, members, this amendment, this is how projects get done in Japan, but it is not how we do things here in Texas. We don't lie and cheat and steal our way, trampling over private property rights, and that's what this amendment does. At the end of the day,
Mr. Speaker,
this is about private property rights.
Will the gentleman yield?
Yes, I would yield.
The gentleman yields.
Thank you, Representative Lamont. This, in fact, was a bill that you filed last session. Isn't this correct?
No, sir, it was not.
This is not. It's not one part of it is a component of a bill you filed last session.
I do not recall a component of this being filed by myself last session. What if you could point to the portion you're referring to?
I would tell you, and I would dispute that there's been any request for public funds. But what we'll get to is this. In fact, are you aware of the amount of private dollars that have been spent on high-speed rail to date to get this project moving?
Mr. Canales, the end does not justify the means.
Members, please confine your remarks to the amendment.
That's not the question, Representative, and I'd appreciate if you could answer my question. My question was, do you know...
The gentleman's time has expired.
Mr. Speaker, I'd ask that respectfully we have the time extended. This is an extremely important debate because this project involves hundreds of millions of dollars, and Mr. Lamont's amendment would kill a project that's been in the process. And so I would respectfully ask that this debate be extended.
Is there objection to the extension of time? The chair hears none. The gentleman's time is extended.
Thank you, Mr. Speaker. Mr. Representative Lamont, I'm going to repeat the...
The chair will remind the members to confine your remarks to the amendment.
Mr. Lamont, I'll repeat the question. You're talking about high-speed rail, and your amendment deals with high-speed rail. Is that correct?
My amendment deals with the right for landowners to repurchase property from any condemnor, including high-speed rail.
Including high-speed rail, and your entire layout right now was dealing with high-speed rail and your assertion that they have been dishonest and all sorts of other allegations. So what I want to do is address that because that's what your amendment is attempting to address in your own words. I'd like to ask you, do you know at this point in time how many hundreds of millions of dollars of private money has been spent on high-speed rail?
So, Mr. Canales, I started to answer it before the gavel was hit and intended on finishing that answer. But as I said, the end does not justify the means. Guardrails need to be put in place to protect private property rights for our landowners. And as we stand here today, not $1 has been spent on turning a shovel. Not one.
Mr. Lamont, you have not answered the question, and that is not true, sir. But what I'll ask you again, this is the third time that I've asked you, do you know how many hundreds of millions of private dollars have been spent on the high-speed rail project that you're ostensibly trying to derail?
To my knowledge, they have held that information confidential and have not released that information, so I cannot confirm.
Members, one last time, please keep your remarks on the amendment.
So
the matter before the House right now is the amendment by Mr. Lamont.
And Mr. Speaker, parliamentary inquiry.
Please state your inquiry.
Is the subject of Mr. Lamont's amendment not high-speed rail?
That is not a proper parliamentary inquiry.
Respectfully, Mr. Speaker, I don't know if you're addressing the comments to me, but my comments are directly on the amendment. And so I'm on the amendment. And so, Mr. Lamont, do you know specifically, you made allegations a few minutes ago that they were now requesting public dollars, can you tell me and the body what public dollars they're asking for?
Yes, I can. There's a letter written by the chairman of the board of Texas Central. Right here's a copy of it in front of me, and I will quote the letter for you so you have it directly from them. The project turned into Mr. Canales.
Representative Lamont,
can you about this amendment, not about the project?
Can you tell me exactly how many pieces of property have been taken by eminent domain?
So what this amendment does is it requires a condemnor, specifically a high-speed rail condemnor, as defined in the current transportation code, to accomplish 3 hurdles in order to demonstrate progress. That is what this amendment does, and I can answer any question about this amendment if you want to ask.
I asked you a pointed question, and I would respectfully ask that you answer it. To date, what land has been condemned for high-speed rail in Texas?
This amendment is not about condemning high-speed rail land or land for high-speed rail. It's about the right to repurchase condemned land. And that's what this amendment is about. So,
Representative Lamont, was this an independent bill that you filed? Or is this just an amendment that you're a standalone amendment? Did you file a bill that had this content in it?
This amendment, Mr. Canales, was attached to this bill that I filed and passed through committee and is now on this bill. Obviously, it's an amendment, so it's not on the,
Representative, is this
not on the bill.
Was
That's
this
why I'm offering it as an amendment.
Mr. Representative Lamont, I'm asking you a simple question. I'd appreciate it, the answer. Was this amendment a standalone bill at any point?
We're talking about this amendment. This amendment is not or never was a standalone bill.
So your amendment was never vetted by a committee. It was never heard. There was no testimony on it. This is the first time that this very important legislation is before this body, and it's never been through the actual process. Is that correct?
The concepts on this amendment have been fully discussed.
Can you tell me where they were discussed?
In their
what
application,
committee?
all this amendment, let's just take, for example,
Representative Lamont, what committee were they discussed in?
Including the reclamation bond. A reclamation bond is a common practice. It's required across a lot of industries. That's in this amendment. It's been discussed many, many times. It is certainly relevant to this type of infrastructure.
Once again, Representative Lamont, I'll ask you a very simple question. What committee was this amendment and that language before?
Mr. Canales, obviously I'm offering this amendment here on the floor today. This amendment
So the answer is it's never
being
been
considered
before a
right
committee.
here before this body.
It's never been before a committee. Is that the answer, Representative? There's never
This
been witnesses.
amendment-
There's never been testimony. No one's ever heard or dealt with this important piece till today, and you're springing it on us in the third quarter, last minute, trying to circumvent the process. This
amendment has been discussed.
Representative, you said that's not.
This
You said
amendment
you
have
said
been
we didn't.
discussed many times throughout the history of this body. Many, many times.
Representative, you said that's not the way we do things in Texas because we don't do it in Japan. Well, I'll tell you, this is not the way we do things in the Texas House either, sir.
Thank you, Mr.
Ms. Davis, for what purpose?
Will the speaker yield for a question?
Will the gentleman yield for a question?
Yes, I yield for a
The
question.
gentleman yields for a question.
So, Representative Lehman, as I understand your bill, or the Senate Bill 726, it dealt with establishing progress for purposes of those that are doing condemnation. Is that correct? Is that what, to repurchase real property from a condemning entity?
That's incorrect. So
that's not
the
what
bill, the amendment,
No, I was asking if that was what the initial bill was about. And the
we
reason
have to speak about the amendment, Ms. Davis. We have to speak about the amendment. I can't speak on the bill,
You
of
can't
course.
speak on
We can
the-
have a conversation about the bill after, but when we go back to it. But right now, this is the amendment before the body, and this is what we need to
And the
focus
reason
on.
I wanted to ask that question, Mr. Lehman, is based on your amendment, would this mean any and all entities that have the ability to do condemnation, would they have to meet the same requirements you're spelling out for with your amendment?
So in the amendment, it refers to, under B2, Section 1, completing 3 or more of the actions listed in subsection B.
And so would all entities that have that
Okay. The B2 Section 1 refers to completing 3 or more of the actions listed in subsection B.
Also, my
That's part of
question
the
was, does this amendment include all entities that have condemnation authority, cities, counties, railroads, everyone that has condemnation authority? Would they have to comply with these 3 or 4 steps that you set out in your amendment?
Right. So to answer the question,
if the city or county is condemning property and they've not met your 3 standards, would that project be stopped based on your amendment?
That is correct. The referral subject to the amendment refers to completing 3 or more of the actions listed in subsection.
Members, please take your conversations outside the chamber.
The amendment refers to B2 Section 1. On the amendment, it states, this is on the amendment, completing 3 or more of the actions listed in subsection B. Obviously, when you look at subsection B, that's all condom doors.
Answer my question. I'm trying to get clarification. Does your amendment require our counties, our cities, and the state and other entities who have condemnation authority, if they have projects that have not met this standard, are they going to be stopped based on your amendment?
This amendment is about high-speed rail projects.
So this is about high-speed rail only.
The gentleman's time has expired.
We've already done it once. Speaker.
The chair recognizes Mr. Anchia to speak in opposition of the amendment.
I apologize.
Thank you, Mr. Speaker and members. I'm grateful for the opportunity to speak on this, and I will be voting against this amendment. The high-speed rail project is really important to Texas as a state, but especially important to the Harris County area, to North Texas, and there's a regime in place for condemnation purposes that our proponents of high-speed rail are following today, and they've put billions of dollars of private capital, not public monies, but private capital at risk. And this amendment effectively undoes a lot of the work that they've been doing and instead moves the goalpost back. So suddenly, and if we're trying to be a globally competitive place to invest billions of dollars, suddenly this legislature is going to say, no, we changed our mind about the rules. We're going to move the goalpost back. You thought you were on the 10-yard line. You thought you were on the 30-yard line. No, we're going to move it back another 10, 20, 30 yards. And that sends a really bad signal to investors who are seeking to invest in the 9th largest economy in the world. So for people from North Texas, for which this project is very, very important, if you're in Tarrant County or Collin County or Denton County, for people in Harris County, for which this project is very important, and all along the way, we cannot be sending the signal, members, that we are open for business, and then when you have billions of dollars of private capital at risk, suddenly we're going to change the rules on you midstream. It is unfair for business, it is unfair for investors, and it is not the signal that we want to send to investors from all over the world where we are seeking to be a place of business. We are trying to live up to that tradition that we have here in Texas of a great place to do business. Do not send this signal to the marketplace.
Mr. Speaker.
Ms. Davis, for what
Will the
purpose?
gentleman yield for a question?
Will the gentleman yield for questions?
I do.
Thank you. Chairman and Chair, are you aware that there's no property been condemned for high-speed rail? That they not condemned any property?
That's right. They've been able to engage in negotiations with landowners and come up with amenable solutions to all parties.
Mr. Chairman, are you aware that they've not taken any public funds to date to be involved in this project? They have no public funds?
That's exactly right, Madam Chair. And I just want to emphasize
Members, please confine your remarks to the amendment before the chamber.
I just want to emphasize that point because under this amendment, the private capital at risk would suddenly have yet another regulatory hurdle in place by changing the rules of condemnation. And because these are private dollars, we're sending a bad message to the investor market about whether or not you should put your money in Texas. And I think we need to be sending just the opposite. We need to be letting foreign investors, domestic investors know that Texas is open for business.
And Chairman and Chair, are you aware that one of the challenges for Texas has been mobility and easing congestion in the state of Texas? And this project has the ability to do that, provide some relief from congestion?
Look, the Lamont Amendment will just make it more expensive of a project. It will run up building costs. It will cost slowdowns in this project, and it'll hurt the private capital at risk. This is the wrong message to send, members, and I ask that you vote against this amendment. Thank you, Mr. Speaker and members.
The chair recognizes Mr. Harris to speak in favor of the Lamont amendment.
Thank you, Mr. Speaker. Members, I'm going to keep this very, very simple. This amendment is about private property rights, pure and simple. That's why you should be in favor of this. State law, as it currently is, does not contemplate the technologies of the high-speed rail, and that's why this amendment is greatly needed to protect landowners throughout Texas. Thank you.
The chair recognizes Ms. Gonzalez of El Paso to speak in favor of the Lamont amendment.
Members, one of the most important economies we have in Texas is our agricultural community. When we start to impact agricultural communities in one part of the state, there is a domino effect to other parts of our agricultural industries. If we do not protect and preserve Texas agriculture, it will not exist 20 years from now. I am proud today to be a rural Democrat fighting for Texas agriculture and Texas rural communities, and I urge you to vote 1 for our communities. Thank you.
The chair recognizes Mr. Toth to speak in favor of the amendment.
Members, my parents were impacted by a project like this, and they never recovered. I pray and ask that we support private property rights and vote for this amendment.
The chair recognizes Mr. Canales to speak against the amendment.
Mr. Speaker, members, quite simply, this is a full-blown, very in-depth bill that has not even remotely been through the process. Representative Lamont couldn't answer one question regarding the process. It's never been debated. It's never had witnesses. No one's come to testify. We've not had one thing happen the way it's supposed to happen. You know what? Maybe this is a good bill. I don't believe so. 1 minute. I don't believe so. But the reality is that the body should have the opportunity to have the process work. We watched at the beginning of session. We're doing it now. This is a very, very complicated subject that requires experts, requires the testimony, and the members should have the benefit of the process before making a decision that could adversely affect Texas for generations. I'm a property rights advocate in every bone of my body. But the reality is that this is not a proper way to handle a bill that should have gone through the process. And I would urge you to let the process work. If Mr. Lamont felt so passionately about this, he should have filed a bill. He shouldn't try to have snuck it in last minute and not be able to answer one single question about it. This is disingenuous, and I urge you to vote no.
The chair recognizes Mr. Ashby to speak in favor of the amendment.
Thank you, Mr. Speaker. Members, I wasn't planning to get up here and speak, but I've been looking at Representative Lamont's amendment, and I've been listening to the discussion here today. And, I think there's been a good amount of healthy discourse here in terms of for and against.
Members, please take your conversations outside of the chamber.
But at the end of the day, for me, first looking at this is a good bill. Representative Lamont, this is a good bill. And for me personally, and actually looking at what's on this piece of paper and what this amendment and what you're trying to basically put into the bill, to me as I read it, there's nothing on here that kills this project, the proposed high-speed rail project. There's nothing. This body spoke a couple of sessions ago when I brought a bill forward that said that we would spend no taxpayer dollars in the state of Texas on a high-speed rail project. And that bill passed almost unanimously across this floor. So I know that there is agreement on this in this body at some level on high-speed rail. But what I think what Representative Lamont is doing is taking a very thoughtful approach. And with this amendment, it doesn't kill the high-speed rail project. It just puts some best practices in place on the actual progress that we talk about in the larger bill on condemnation. So I think this is a common sense amendment. This does not kill the high-speed rail project, and I appreciate Representative Lamont for bringing it, and I encourage my colleagues to vote for it. Thank you.
Mr. Speaker.
Mr. Rosenthal, for what
Does the
purpose?
gentleman yield for a question?
The gentleman yield for a question. The gentleman yields.
I will always yield for a question.
Thank you, Mr. Ashby. I do appreciate
You bet, Mr.
your
Rosenthal.
patience with me.
Absolutely.
Because I'm not that smart and I need to ask some questions.
Oh, don't start that game.
So the assertion that you just made that there's nothing on this amendment that kills the high-speed rail, that
Correct.
30-year bond is not prohibitive in any way to you?
No, it does. Well, you use the
Is
word
that a re-
prohibitive, okay? That is different than killing the project.
Cost
If you read
prohibitive.
what it says here, it just
Cost
says that
prohibitive.
they would obtain a 30-year reclamation bond determined by the Attorney General to be sufficient to restore any affected property to its original condition if
So-
the project fails. If the
So would you
project
agree?
doesn't fail,
So would you agree the amendment implements a strong financial requirement that did not exist prior to the amendment?
So it only applies to land that is condemned, and it only applies if the project fails. And I think we've heard from a lot of the advocates for this project that this project won't fail.
Actually, so you're going to have to help me again because I'm not a lawyer. But the
Well, then we'll have a
language
great
in the
discussion.
the language in the amendment, to me, it looks like you have to procure this bond in case that the project fails. So that means you have to get the bond in advance as insurance against the project failing. Is that not true?
That is correct. Absolutely.
Okay, so we are adding a cost to a project that actually wasn't even part of the original bill in any way, and I would submit that this 30-year bond is probably going to be pretty expensive, don't you think?
No, I'm not in the insurance business, so I have no idea. But what I would tell my good friend from Houston, as you know, this is a common practice. This is a best management practice. So again, this is nothing out of the ordinary. But I appreciate the question.
All right, thank you so much.
The chair recognizes Mr. Lamont to close on the amendment.
Thank you, Mr. Speaker. Members, make no mistake, I know there's a lot of confusing topics trying to get in the weeds on what this amendment does with respect to high-speed rail, but this is a private property rights amendment. That is what it is. We have a project that is unique.
Members, please take your conversations outside the chamber.
Hang on. That is a project that is unique in its construction and the impact, and therefore requires circumstances to address that as it relates to progress, and that's what this amendment does. I've been up and down this corridor where landowners have been abused and treated unfairly, and members, this is a private property rights vote. I'm encouraging you to stay with me on this. Please vote 1, move adoption.
The question occurs on adoption amendment. A record vote is requested by Mr. Bernal. The clerk will ring the bell. Members, you have plenty of time to vote from your desk. Mr. Patty voting aye. Mr. Bell Montgomery voting aye. Dr. Oliverson voting aye. Ms. Click voting aye. All members voting. There being 57 ayes and 84 nays, the amendment fails to adopt. Any member would speak for, against, or on the bill. The chair recognizes Mr. Lamont to close on the bill.
Thank you, Mr. Speaker. I encourage you to support this bill. It's a good bill. I close.
The question occurs in passing the engrossment pass the third reading, SB 726. A record vote is requested by Ms. Israel. The clerk will ring the bell. So Mr. Harris voting aye, Mr. Lamont voting aye, Mr. Bella Montgomery voting aye, Ms. Click voting aye. All members voting. There being 91 ayes, 50 nays, SB 726 is passed the third reading. Ms. Lamont moves that HB 2044 be laid on the table subject to cause. There's objection to the motion. Chair hears none, so ordered. The chair lays out HB 4055 as a matter of postponed business on second reading. The clerk will read the bill.
HB 4055 by Mesa relating to reporting and investigating certain cases of child abuse or neglect involving a pregnant woman's use of a controlled substance.
The chair recognizes Ms. Mesa to explain the bill.
We've heard a lot today about the barriers that Texas women face when it comes to being pregnant. Imagine two scenarios. In one scenario, a woman is expecting a child, but she knows she has a substance abuse problem. She's afraid to seek treatment, even though she wants to, because she knows that she might be reported and that she might risk her child. So she doesn't seek treatment. So we have an unhealthy mom, an unhealthy baby, and a baby when born is at risk of losing her child. In the second scenario, the mom knows that has a comfort level in talking to her doctor about seeking substance abuse treatment. We have a healthy mom, a healthy baby, and when the child is born, a child that can stay with its mother. This bill creates a safe harbor for both pregnant mothers who are seeking care for substance abuse treatment and the doctors are treating them by adding language to the section of the code that outlines the duty to report. The language added to the statute removes medical professionals from providing care to pregnant women from the list of persons required to make a report of child abuse or neglect under the existing law. The provider or caregiver is not required to report an instance of child abuse involving a pregnant mother if the mother is seeking treatment or successfully completed a substance abuse program. This bill passed unanimously out of the House Services Committee. It's supported by a broad range of advocacy groups, including Texans Care for Children, Texas Public Policy Foundation, the National Association of Social Workers, the Texas Catholic Conference of Bishops, Tex Protects, and more. So, and I hope that we'll also have your support. I believe there is an amendment.
Following amendment, the clerk will read the amendment.
Amendment by Whole.
The chair recognizes Ms. Hull to explain the amendment.
Thank you, Mr. Speaker. Members, this amendment ensures that this applies only to a woman who is currently enrolled or has recently completed a substance abuse treatment program or who has made reasonable efforts to enroll in a substance abuse program within 5 days. It's acceptable to the author. Move adoption.
Ms. Hull sends up an amendment. The amendment is acceptable to the author. The objection to adopt the amendment. Chair hears none. Amendment is adopted. Chair recognizes Ms. Meza to close on the bill.
Thank you. This would be a safe harbor bill, and I hope that you'll move passage. We'll move passage.
The question occurs on passing the engrossment of HB 4055. A record vote has been requested by Mr. Patterson. The clerk will ring the bell. Show Ms. Hull voting aye, Mr. Sanford voting aye, Ms. Meza voting aye. All members voting. Show Ms. Meza voting aye. Show Mr. Parker voting aye, Mr. Burrows voting aye. All members voting. There be 91 ayes, 49 nays. HB 4055 is passed in engrossment. Mr. Metcalf has an announcement.
Thank you, Mr. Speaker. Members, there are fish tacos back here for purchase. Yes, enjoy it.
The chair lays out on second reading HB 186. Chair lays out on second reading, third reading HB 1869. The clerk will read the bill.
HB 1869 by Burrows, relating to the definition of debt for the purposes of calculating certain ad valorem tax rates of a taxing unit.
The chair recognizes Mr. Burrows to explain the bill.
Yes, Mr. Speaker, members, this is the bill we started hearing yesterday. I believe there's a few amendments.
Following amendment, the clerk will read the amendment.
Amendment by Cyrier.
The chair recognizes Mr. Cyrier to explain the amendment.
Hey, members, we worked on this a little bit today and got it fixed up. It's clarifying what we worked on, and it is good, and I believe there's an amendment to the amendment.
The following amendment to the amendment, the clerk will read the amendment.
Amendment by Fasut.
The chair recognizes Mr. Fasut to explain the amendment to the amendment.
Thank you, Mr. Speaker. Members, good amendment to the amendment. Move adoption. Acceptable to the author.
The following, Mr. Fasut says on amendment, the amendment is acceptable to the author's objection to adopt the amendment. Chair hears none, amendment is adopted. The chair recognizes Mr. Cyrier to close on the amendment as amended.
Move adoption.
Mr. Cyrier sends up the amendment as amended. The amendment is acceptable to the author's objection to adopt the amendment. Chair hears none, amendment is adopted. Following amendment, the clerk will read the amendment.
Amendment by Rodriguez.
The chair recognizes Mr. Rodriguez to explain the amendment.
Thank you. Thank you, Mr. Speaker. This amendment simply excludes Travis County. I believe it's acceptable to the author.
Every member of your delegation accepts it? Yeah.
Mr. Rodriguez sends up the amendment. The amendment is acceptable to the author's objection to the amendment. Chair hears none, the amendment is adopted. Following amendment, the clerk will read the amendment.
Amendment by Ordaz Perez.
The chair recognizes Ms. Ordaz Perez to explain the amendment.
Member of the delegation accepts is on it.
Good. Thank you, Mr. Speaker. Members, this amendment is acceptable to the author. It excludes El Paso. I move adoption.
Mr. Speaker.
Mr. Moody, for what purpose?
The gentlelady yield for a question.
Will the lady yield for a question?
Yes,
She
I yield
yields.
for a question.
Okay. I noticed there were some other names on that amendment. Does that include the entirety of the El Paso delegation on that amendment?
That does. Speaker Moody, Dr. Mary Gonzalez, Representative Lena Ortega, Representative Fierro, and myself.
Well, we don't care about art, but thank you very much.
Move adoption.
Ms. Ordaz presents an amendment. The amendment is acceptable to the author's objection to adoption of the amendment. Chair hears none, the amendment is adopted. Following amendment, the clerk will read the amendment.
Amendment by Bowers.
The chair recognizes Ms. Bowers to explain the amendment.
This amendment will exempt Dallas County and the political subdivisions contained therein for the provisions of this bill.
So there's an objection.
The chair recognizes Mr. Burrows to speak on the amendment.
Mr. Speaker, members, the entire delegation of Dallas County has not signed off on this amendment, so I will leave it to the will of the House and let everyone decide what they want to do on that.
The chair recognizes Ms. Bowers to close on the amendment.
I move adoption.
Ms. Bowers sends with an amendment. A record vote has been requested by Ms. Bowers. The clerk will ring the bell. Show Ms. Bowers voting aye. So Mr. Cyrier voting no. Mr. Burrows voting no. Mrs. Wiener voting aye. Ms. Davis voting aye. All members voting. There being 71 ayes and 68 nays, the amendment is adopted. Following amendment, the clerk will read the amendment.
Amendment by Lozano.
Chair recognizes Mr. Lozano to explain the amendment.
Thank you, Mr. Speaker and members. This amendment simply removes Clayburgh County, Jim Wells County, B County, and San Patricio County. Thank you, Mr. Speaker and members. This amendment simply moves the 4 counties I represent, Jim Wells County, Clayburgh County, San Patricio County, and B County.
Mr. Lozano sends an amendment. The amendment is acceptable to the author's objection to adopt an amendment. Chair hears none, the amendment is adopted. The following amendment, the clerk will read the amendment.
Amendment by Herrero.
The chair recognizes Mr. Herrero to explain the amendment.
Thank you, Mr. Speaker. Members, this amendment exempts Nueces County, and I believe it's acceptable to the author. Yes.
Mr. Herrera sends an amendment. The amendment is acceptable to the author's objection to adopt the amendment. Chair hears none, the amendment is adopted. Following amendment, the clerk will read the amendment.
Amendment by Turner of Tarrant.
Chair recognizes Mr. Turner of Tarrant to explain the amendment.
Speaker, this amendment simply exempts the county with a population of more than 1.5 million. Move adoption.
Mr. Speaker.
Mr. Tinderholt, for what purpose?
Does the gentleman yield for a question?
The gentleman yield for questions.
Yes.
Does this bring Tarrant County into this fray?
Well, it would remove Tarrant County, actually. If Tarrant County is in the bill, it would remove Tarrant County.
So are you aware that today I just talked to the Police Association president and I went through everything? I think the city had asked for Fort Worth to give me a call. I went through all of the items that the amendment had yesterday for Tarrant County, and I think about 50% of the Tarrant County reps are for what you're doing and about 50% are against. And with the amendment yesterday, they can still buy police and fire equipment. They can still do a lot of things that a city's required. I'm totally against this amendment, and about 50% of the delegation is against this amendment for Tarrant County.
Well, I appreciate that, Representative Tinderholt, and I didn't get a chance to, with a lot going on today, I didn't get a chance to talk to everybody in the delegation. I talked to a few people. And look, I agree, those amendments yesterday were helpful. They were, and I'm very glad that Chairman Burrows accepted those amendments yesterday and put them on the bill, because that, I would agree with you, it certainly helps our communities. But I think you've seen that a number of communities around the state have successfully exempted themselves from this bill, and I just wanted Tarrant County to be on an equal playing field and have the same, be treated fairly, just like El Paso County is being treated, Travis County, Bexar County, Nueces County, and several other counties that have already been exempted. So that's all my amendment would do.
Right, and I hear what you're saying. There's 254 counties. We're one of them, and there's only a handful right now that are exempted from it. And my goal is to protect the taxpayers. I want the cities to still be able to use these COs when they're necessary, and we're fortunate. Most of the places in our county won't be abusive right now, but we don't know that they won't be in the future. So I'm going to oppose your amendment, and I'm hoping that the Tarrant County delegation that are against it would oppose it, and I'm hoping that the members in the House, because 50% of Tarrant County delegation is against this, I hope you'll also consider voting with us to oppose this amendment. Thank you, sir.
Thank you, Representative Tinderholt. We just have an honest difference of opinion on this. I think it's only fair that we not include Tarrant County in this bill when so many other counties around the state have already been exempted. So I would move adoption.
Leave it to the will of the House. I'll just let the members.
The chair recognizes Mr. Burrows to speak on the amendment.
I'll leave it to the will of the House since the delegation split.
Mr. Turner of Tarrant sends up an amendment. A record of vote has been requested by Mr. Goldman. The clerk will ring the bell. So Mr. Turner of Tarrant voting aye. Mr. Burrows voting nay. Mr. Cyrier voting nay. Ms. Wiener voting aye. Ms. Bowers voting aye. Ms. Click voting nay. All members voting. There being 70 ayes, 71 nays, the amendment fails to adopt. Members, earlier, the chair erred in announcing the outcome of the vote on the Bowers amendment. The amendment did require a two-thirds vote. A two-thirds vote was not achieved. Please reflect that amendment failed. The following amendment, the clerk will read the amendment.
Amendment by Turner of Tarrant.
The chair recognizes Mr. Turner of Tarrant to explain the amendment.
So is that okay? Yeah, it's fine. Okay. Thank you, Mr. Speaker. Members, this is a different amendment. This only affects the city of Grand Prairie. It just takes out a municipality with a population of more than 150,000, less than 200,000. That's partially located in a county with a population of 1.8 million or more. It only affects Grand Prairie. I move adoption.
Mr. Turner of Tarrant says the amendment is acceptable to the author of the objection. Adoption of the amendment. The chair hears none. The amendment is adopted. Any member wish to speak for, against, or on the bill? The chair recognizes Mr. Burrows to close on the bill.
Passage.
The question occurs in passing the engrossment of HB 1869. Pardon me. The question occurs in passage of final passage of HB 1869. There's a record vote. The clerk will ring the bell. Show Ms. Bowers voting nay, Ms. Click voting aye. All members voting. There being 111 ayes, 29 nays, HB 1869 is finally passed.
Mr. Speaker.
Mr. Doorkeeper.
Mr. Speaker, I have a messenger from the Senate at the door.
Admit the messenger.
Thank you, Mr. Speaker. I'm directed by the.
The chair lays out on second reading HB 9. The clerk will read the bill.
HB 9 by Click, relating to criminal punishment and conditions of community supervision for the offense of obstructing a highway or other passageway, increasing a criminal penalty.
The chair recognizes Ms. Click to explain the bill.
Thank you, Mr. Speaker. Members, this is the bill we debated last week, creating enhancement to the current offense of obstructing a highway or roadway if the actor knowingly prevents the passage of an authorized emergency vehicle. I move passage.
The following amendment, the clerk will read the amendment.
Amendment by Ann Johnson of Harris.
The chair recognizes Ms. Johnson to explain the amendment.
Thank you, Mr. Speaker. Members, this amendment just acknowledges that the concern that maybe this particular piece of legislation is politically motivated and could be used as a forum to prosecute people who are protesting. This affirmative defense provides that if there were an alternative route that an ambulance or emergency vehicle could take to get around that protest, then it can be brought up in punishment. The person would still be prosecuted for obstruction, but it clearly acknowledges the potential for an affirmative defense to prove to people that the intent of this legislation is not politically motivated. To prove that point, I ask that you vote yes on this amendment.
The question occurs on adoption of the amendment. Ms. Johnson has requested a record vote. The clerk will ring the bell. Show Ms. Click voting nay. Show Mr. Harless voting nay. Show Ms. Bowers voting aye. All members voting. There being 58 ayes, 80 nays, the amendment fails to adopt. Any member which speak for, against, or on the bill? The chair recognizes Ms. Click to close on the bill.
Mr. Speaker, members, I move passage.
The question occurs on passing the engrossment of HB 9. Mr. Biederman has requested a record vote. The clerk will ring the bell. The clerk will ring the bell. Show Ms. Click voting aye. Ms. Bowers voting nay. All members voting. There being 84 ayes, 60 nays, HB 9 is passed to engrossment. The chair lays out on second reading HB 1925. The clerk will read the bill.
HB 1925 by Cabriclione relating to prohibitions on camping in a public place creating a criminal offense.
The chair recognizes Mr. Cabriclione to explain the bill.
Thank you, Mr. Speaker and members. This is the homeless camping ban bill that I brought to you, or attempted to bring to you, a few days ago. Since that time, a few things have changed, but some things most certainly have not. In the first major local referendum on this subject, the voters of Austin, voted in large numbers to reinstate the ban on camping in prohibited places. When voters and votes on this subject happen, either in the past or throughout this country, voters time and time again agree with the fundamental principles in this bill. But I'll tell you that some things have stayed the same. Unsheltered individuals are left literally out in the cold. These individuals are mistreated and untreated. Public safety and public health are at risk. This bill would ban camping on public land without permission from the appropriate agency. This bill does not make being homeless illegal in Texas. And I'll say again what I said back then, that there's still no one, literally no one, that believes that people living outside without shelters is right. This is a humanitarian issue, plain and simple. This is about people, someone's brother, sister, mother, father, son, or daughter, living under a bridge in extreme conditions, whether hot or cold, without a roof over their head. What this bill does is it prohibits local entities from adopting or enforcing policies that prohibit enforcement of public camping bans and authorizes the state to take legal action against entities that do not comply. This bill prohibits any municipal entity from prohibiting or discouraging the enforcement of any public camping ban. And this bill, members, helps individuals, families, and business owners across the state who are unduly subjected to violent or hazardous activity linked to the rise in public camping. The homeless population will also benefit from this legislation, especially with the key change in my amendment coming up. Although some argue that some individuals might be hurt by the lack of available camping spots, allowing people to live on the street incentivizes them to remain unhoused rather than get the support services they need in permanent housing. So that, members, I do have an amendment.
Following amendment, the clerk will read the amendment.
Amendment by Capriglione.
The chair recognizes Mr. Capriglione to explain the amendment.
Thank you, Mr. Speaker. Members, this amendment incorporates a few clarifications and changes. It adds temporary, semi-permanent, or permanent to the definition.
Ms. Weiner, for what purpose?
Will the gentleman yield for a question?
The gentleman yield for questions.
If you don't mind, maybe I'll just explain the full amendment, and I'd be happy to entertain any questions. So what this amendment does is it adds temporary, semi-permanent, or permanent to the definition of shelter to make clear that when designating a place to camp, you can use other types of structures than just a tent. It clarifies that recreational camping in city, county, and state parks will not be affected. It will also not affect areas that have beach access plans that are approved by the state. It explains that the Texas Department of Housing and Community Affairs will serve as the agency the political subdivisions will seek approval from when wanting to create community-led camping areas. And finally, it requires that political subdivisions who seek approval to create camping areas must include, and I think this is important, members, it must include wraparound services with the campsite, such as healthcare, mental health care, indigent services, public transportation, and law enforcement. Representative Weiner, I'm happy to answer any
Yes, Mr. Speaker.
Ms. Weiner, for what purpose?
Does the gentleman yield?
Does the gentleman yield for question? Gentleman
I
yields.
do.
Thank you so much, Representative. As I'm looking at this amendment, I am curious, does this requirement for a plan under TDHCA apply to just public areas, or does it apply to any property?
This applies, it's an area by which a process by which areas can designate property for camping by homeless individuals. The process would have plan requirements to ensure that the designated camp area had the availability of reasonable health and safety services. So this is for public areas.
Okay, is public areas in this amendment? As I'm reading this, it applies to any property.
Oh. Let me go through. I don't know where in the amendment it says that, but
Okay.
I'll have to give you that answer in a second.
Mr. Speaker,
Ms. Weiner, for what purpose?
I rise on a point of order under Rule 11, Section 2, that the amendment is not germane.
Please bring your point of order down front. The following amendment to the amendment, the clerk will read the amendment. I'm sorry, the point of order has been withdrawn. The following amendment to the amendment, the clerk will read the amendment.
Amendment by Turner of Dallas.
The chair recognizes Mr. Turner to explain the amendment.
Thank you, Mr. Speaker and members. This amendment to the amendment is acceptable to the author. It just adds one thing to the list of items this bill does not affect, and that is the ability to provide emergency shelter during a declared disaster. Move adoption.
Mr. Turner sends an amendment to the amendment. The amendment is accepted to the author to reject and adopt the amendment to the amendment. The chair has none amendments adopted. The chair recognizes Mr. Capriglione to close on the amendment as amended.
Thank you, Mr. Speaker. Members, again, with this amendment, it does a few different things, but just to be clear, it does require that camping areas include wraparound services with the campsite, such as health care, mental health care, indigent services, public transportation, and law enforcement. Text of the author, I move passage.
Yeah, that's right. Mr. Capriglione says an amendment as amended is acceptable to the author's objection to the amendment as amended. The chair has none amendments adopted. Following amendment, the clerk read the amendment.
Amendment by Turner of Dallas.
The chair recognizes Mr. Turner to explain the amendment.
Thank you, Mr. Speaker and members. This is another amendment to the bill that Representative Capriglione is accepting. It just adds the words "or any handheld device" at the end of the word "clothing" to make sure that this bill doesn't affect a person who is using something like an umbrella or a parasol. Move adoption.
Mr. Turner sends an amendment. The amendment is acceptable to the author. The objection to adoption of the amendment. Chair hears none. Amendment is adopted. The following amendment, the clerk read the amendment.
Amendment by Bernal.
The chair recognizes Mr. Bernal to explain the amendment.
Thank you, Mr. Speaker. Members, this is the same amendment that I, along with Ms. T, offered that would require a peace officer to advise someone of where else they can go to camp if they need to, and also if they need services to provide them with those services and information on the prevention of human trafficking, and as well as anything that might also prevent them from violating the statute. I believe it's acceptable to the author. Move adoption.
Mr. Bernal sends up an amendment. The amendment is acceptable to the author's objection to the adoption amendment. Chair hears none. The amendment is adopted. Following amendment, the clerk read the amendment.
Amendment by Moody.
The chair recognizes Mr. Moody to explain the amendment.
Thank you, Mr. Speaker, members. Mr. Capriglione has complained about the strike-throughs that we've done in this, but he's still going to accept it. This does just a couple of things. This ensures that in the event someone is arrested or detained, that they have an opportunity to remove property, or if a person is taken into custody, that that property is maintained until they're able to retrieve it. The other part of the amendment ensures that if a city has a policy that encourages diversion or provision of services in lieu of citation or arrest, that's not prohibited by the bill. And so we want to encourage jurisdictions to figure other ways other than the criminal justice system to solve these issues, and this amendment encompasses that. So I move adoption.
Mr. Moody sends up an amendment. The amendment is acceptable to the author. The objection to the author of the amendment. Chair hears none. The amendment is adopted. Following amendment, the clerk read the amendment.
Amendment by Gervin Hawkins.
The chair recognizes Ms. Gervin Hawkins to explain the amendment.
Thank you, Mr. Speaker. Members, we must really think about this bill and what it does to potentially criminalize people, particularly homeless folks. Currently, the way HB 1925, as written, would actually forbid officers from giving a warning and giving people a chance to comply. My floor amendment would fix that. Cities like San Antonio support the amendment and so do other small cities. We do not need to push these policies on rural and suburban areas where they don't apply and will create an additional burden on local officials and law enforcement. Can you imagine if we're picking up a number of homeless people and trying to put them in the local county jail? The amendment will allow a law enforcement officer to provide an individual with a warning and give them a chance to comply before a fine is given. How can you ask someone for $500 and they have nothing? Criminalizing involuntary behavior like sleeping does not make it easier for people to escape homelessness. In fact, it's much harder. We cannot fix this problem with a broad brush. When you look at homelessness, there's reasons why people are homeless. It could be they're down on their luck. It could be they've been abandoned. It could be those kids that age out of foster care. It could be many different factors, including mental illness, and on and on and on. What this amendment does is just give the officer the authorization to give notice to cure, to make sure individuals can pack their stuff, leave, and find other resources. With that, I move adoption.
The chair recognizes Mr. Capriglione to speak against the amendment.
Thank you, Mr. Speaker. Members, I do object to this amendment. In the way that this is drafted, it would actually basically would help gut the bill. But I think what Representative Moody did is actually helpful in terms of how these individuals are treated. So with that, members, I ask you to vote no on this particular amendment.
The chair recognizes Mr. Gervin Hawkins to close on the amendment.
We are all entitled for notice. If you've done something that is not within the law, or you want to resolve an issue, we are all entitled to notice. Give our homeless population an opportunity and give them notice. With that, I close.
The question occurs on adopting the amendment. A record vote has been requested by Mr. Biederman. The clerk will ring the bell. Show Mr. Capriglione voting nay. Show Ms. Gervin Hawkins voting aye. Show Ms. Goodwin voting aye. All members voting. All members voting. There being 60 ayes, 80 nays, the amendment fails to adopt. Following amendment, the clerk will read the amendment.
Amendment by Pacheco.
The chair recognizes Mr. Pacheco to explain the amendment.
Thank you, members. My amendment is very simple. It adds the requirement that the court consider the defendant's ability to pay under Section 45.0941 of the Code of Criminal Procedure and shall waive the fine if the court determines the defendant cannot pay. This amendment also strikes the provision under Section 2, which removes local control over how to enforce the law. Move adoption.
The chair recognizes Mr. Capriglione to speak against the amendment.
Thank you, Mr. Speaker. Members, we already have in Texas Code of Criminal Procedures 45.049 the ability for justices or judges to make the determinations. I do not think we should go and prescribe that in law to how judges should rule. So with that, I ask that you vote now.
Ms. Israel, for purpose?
Mr. Speaker, will the gentleman yield for a question?
Would the gentleman yield for a question?
Yes.
The gentleman yields.
Rep. Capriglione, my understanding of that amendment is that I understand what you're saying in that you want judges to have the variables of fine or no fine, but why would you place a fine on someone who's homeless and doesn't have the ability to pay, and then when they don't pay the fine, they've got a record and you've exacerbated their problem? Wouldn't it be better to make a blanket statement on behalf of the state of Texas, as every city is dealing with this issue?
Well, I mean, to be honest, I mean, there's three branches of government, and it's our job to go and make laws. But in the current, again, Texas Code of Criminal Procedures 45.049, what we say is, and this is already in statute, a justice or judge may require a defendant who fails to pay a previously assessed fine or cost, or is determined by the court to have insufficient resources or income to pay a fine or cost, to discharge all or part of the fine or cost by performing community service. And there's other parts of this
bill. So it doesn't concern you that one judge in Fannin County will say fine and another judge in Travis County will say no fine? That this is an opportunity for us to make your bill better.
I think we're going to trust the justices and judges in each community to make these decisions.
All right. Thank you.
Thank you.
The chair recognizes Mr. Pacheco to close on the amendment.
Members, this is a very good amendment. It's not complicated, and I just want to close by saying it should not be a crime to be poor and homeless. Thank you. Move adoption.
The question occurs on adoption of the amendment. Record of vote has been requested by Mr. Biederman. The clerk will ring the bell. Show Mr. Cabriglione voting nay. So Mr. Toth voting nay. So Ms. Goodwin voting aye. So Ms. Hinojosa voting aye. All members voting. There being 62 ayes, 79 nays, the amendment fails to adopt. Any member will speak for, against, or on the bill. The chair recognizes Ms. Goodwin to speak against the bill.
Thank you. Thank you, Mr. Speaker. I hate the homeless problem.
Members, please take your conversations outside the rail.
I hate the homeless problem in Austin. Everyone does. But House Bill 1925 doesn't solve this problem. House Bill 1925 does not address the root causes of homelessness. Let's consider how the state could be addressing this issue. Number one, improve our foster care system. Members, did you know that 40 to 50% of foster youth become homeless within 18 months of emancipation? That is a failure of our foster care system. Two, pay a living wage. 20% of the homeless population are employed. Bills to increase the minimum wage did not even receive a hearing this session. Due to state law, cities can't raise their minimum wage to account for ever-increasing cost of living, ever-increasing rents and housing prices here in Central Texas. Number three, keep people from that initial night on the streets through rental assistance aimed at those who are in imminent threat of eviction. The federal government sent $1 billion flowing through the state. Cities and counties also have rental assistance programs. What is the state doing? We need more state dollars going to substance use disorder programs, job training programs, and rental assistance. If we truly want to end homelessness, we need to address the root causes, not just sweep the homeless population back into the woods.
The chair recognizes Mr. Toth to speak in favor of the bill.
Members, we don't have a homeless problem so much as we have a mental health crisis in Texas that masks itself as a homeless problem. I've been working with veterans for the past 10 years, and many of the people that you meet on the streets here in Austin and other cities across the United States, many of them are veterans that have mental health problems. We are not doing them any favor by continuing to enable them to live out on the streets. The vast majority of the people that are arrested in Montgomery County and in counties across the state of Texas are folks that have mental health problems. We don't help them by leaving them on the streets. Please support this bill.
The chair recognizes Mr. Capriglione to close on the bill.
Thank you, Mr. Speaker, members.
Ms. Israel, for what purpose?
Will the gentleman yield when it's appropriate?
Would the gentleman yield for questions?
Yes.
Gentleman
Thank you,
yields.
Mr. Speaker. Thank you, Rep. Capriglione, for allowing us to question you about the bill. Now that we've gotten this amendment on there about approval for homeless camps, for lack of a better word, approved camps, my concern is that it's going to an agency that doesn't know how to do this.
Well, I think the
Do you have
current
that
homeless
same concern?
situation went to a city
What's your
government that
reaction
didn't
to
know
that
how to
concern
deal
that
with
I have?
this.
Go ahead. I'm sorry, I couldn't hear you.
No, and my concern is that in some cases it went to a city government that doesn't know how to handle the homeless situation.
I'm sorry, we couldn't hear you.
I guess what I was saying is that
Members, please take your conversations outside the chamber.
I guess what I was saying was that it's my concern as well that some city governments don't know how to handle the situation either.
I don't think that's a fair comparison, Representative, because cities at least have a variety of staff at their resources, and they have the ability to build coalitions with our faith-based groups. And do you share the same concern that I do in that the Department of Housing and Community Affairs only does tax credit programs at this juncture? They don't know how to do these kinds of evaluation and set up their criteria.
As you know, as the legislative body, we can ask and we can require that agencies work on a variety of different things, and this is one of those things. I think TDHCA will do a great job in doing this.
How do we know that?
This is a moment, it's not my close, but I do want to answer your question, because this is, in this whole entire episode of working on this legislation, the one part that has befuddled me, Representative, is the fact that, quite frankly, some in the Austin delegation and others have opposed this wraparound service section. This is the part of the bill, this is the part of the legislation that I was hopeful that we could all agree with. All right.
You mentioned when you brought this bill up a few days ago that there was some appropriation tied to this. Could you elaborate on that?
There's a lot of different items inside of the bill, if you like, although I'm afraid it may take most of the remaining time, but I do have a list of various agencies, various dollars, various programs, various statutes and centers funded by the state that provide everything from health care to mental health services, employment services, workforce training services, transition services to the homeless. In fact, in one of the recent federal allocations, a significant amount of money will become available to help homeless individuals.
Now that this amendment has gotten on, is there a fiscal note change to your bill?
There is no fiscal note change to this bill. I will say we're in the process right now, other than the fact that I'm here, but right now we're in the process of continuing to work on the appropriations process, which, as you know, does mostly concern dollars being spent in various government programs.
Representative, was there a hearing in which TDHCA staff and others were able to speak to their ability to monitor these camps, approve these camps, and move forward with the planning of these camps?
I'm not advised.
So you don't, it's a part of your bill now. Was there any kind of hearing about their capabilities?
Was there a hearing on their capabilities? Not in relation that I was there in the last few days.
Thank you.
Ms. Howard, for what purpose?
Would the gentleman yield for some questions?
Would the gentleman yield for questions?
I will, yes.
He yields.
Thank you, Representative Capriglione. I was going to ask you some about the budget as well, because I understand, is it not correct that you have a contingency rider in the budget based on the passage of this that would provide a certain amount of funding?
I have a contingency rider, and as I kind of pointed out before, there's a whole host of other programs and other dollars that are also dedicated, or at least partially dedicated, to issues related to homelessness and those who are unsheltered.
Right. I mean, and we know that there's a variety of funding mechanisms throughout the budget that can be accessed. There's not any big, huge pot of money, though, for this issue. But in regard to this bill, I just wanted to ask you about what you have as a contingency. Is it correct that it's $12.5 million each year of the upcoming biennium?
I think it was 25 million for the full biennium, so
Right.
half per year.
So, right. So 25 million more. Do you know what the budget to the three programs that currently exist within, that are for the housing programs within TDHCA are? Do you know what that budget is?
Well, I have a list here. If you want, I can go through.
Well, I'll
I
ask
think-
you if you
okay.
know then that what I saw was 50.4 million.
Okay,
Does that sound correct?
I'll take your word for it.
Okay. So you're well aware of the fact, I know, that Austin just had an election and that
Yes, congratulations, by the way.
yeah, and so the local community made a decision.
I
So-
think a pretty strong decision, and that's kind of what this would go to, and that's what I'm really proud of, is so many voters in a city that was faced with this issue that was brought on by the elected officials in Austin. They voted with their feet. They drove, I think, pretty record numbers for a local election like this, and I think on Proposition B, they voted correctly. And I think that for us that are elected officials, that's who we should be listening to, right?
Well-
we should be listening not just to some folks. We should be listening to the voters.
So in fact, they are listening to the voters. An election was held, and there are actions being taken that were already being taken. And so actually, local government seems to be working, does it not?
Well, what I would say is if local government, at least in this particular case, had thought this through, they probably would have come up with a plan and implemented it before they put homeless people under bridges.
Well, and they possibly could have known ahead of time about COVID, but of course nobody did. Anyway,
I would say the change in ordinance, at least in the city of Austin, happened before COVID.
Right, it did, right before.
And what I would say, I mean, right, I'm not going to argue Austin politics. I think the voters of Austin did that for us.
I guess what I'm asking you is, would you not agree that the process has worked as it is intended to?
No, I'm sorry. I can't agree that the process that's going on right outside of our walls on the streets in Austin, that process is working. I cannot believe that anyone would think, who would think that going down and looking under bridges, watching people living in squalor, living in feces, living in urine.
Representative Capriglione, do you know that there is a plan in place and that it is being implemented, and that there are incremental stages that need to be put in place to find all of the shelters for these folks? And there's got to be money attached to it as well, correct?
Representative, I think if the plan was to do what's going on right now, it was a very, very bad plan.
The fact is, the local process worked, did it not? We had an election, did we not?
I'm sorry, I just can't agree the fact that if you go down any street in Austin, the fact that our staff, are afraid to go to work walking, the fact that so many residents here, just
and the residents spoke.
Look at the comments on Twitter when people from both parties, this is a bipartisan issue.
Absolutely, I agree with you. I'm just saying the residents spoke. The voters in Austin spoke, did they not?
After how many people died? After how many people had their legs amputated because of frostbite? After how many people moved out of the city? After how many people decided to cancel business conventions?
All right, well, I guess it's not going to be any good for me to ask any questions here other than I'll just get back to the budget for a minute and ask you, the plan that's in place to house 3,000 people over this next incremental period of time that was agreed upon by the summit that was pulled together with not only city officials, but also the Downtown Austin Alliance, the Austin Chamber, local businesses, and advocacy groups. The local community came together and crafted a plan to house a large number of people over a period of time. It's going to cost a certain amount of money. One number that I've seen is $240 million. What I'm going to ask you now, Representative Capriglione, is if you have a contingency rider here for an additional $25 million, are you willing, now that we know that we have additional federal dollars coming into the state, are you willing to look at perhaps increasing the amount of money that might be available? Because that's one community out of the entire state that needs to have access to funds to house the unsheltered.
Well, first, absolutely, this is happening all over the state, which is why we're doing a statewide bill. But when I have looked at the numbers that you're talking about, I'm sorry, but there's, in some cases, spending $150,000 per room for homeless individuals. I don't think that the plan, as I have seen it, it is all within even the realm of fantasy. It's beyond that.
Well, are you suggesting that the Austin Chamber and the Downtown Alliance are working in Fantasyland?
No,
Okay, they've crafted the plan.
No, that's not.
And maybe you want to look at the plan. They crafted a plan that has different options for providing shelter for the unsheltered here in our community. We're moving forward with that plan as we speak. There's probably, my understanding, about 2,000, did you know, about 2,000 unsheltered in Austin right now. And there is an immediate need to find shelter for them now that this is passed. That's going to be a very difficult challenge, but I understand that they've at least located a couple of hundred units that they can repurpose by the folks that were being housed that had COVID, that were unsheltered, and they can now get them in closer quarters. They were having to be distanced because of COVID. So there are efforts being made as of May 11th. As of May 11th, this ordinance will be changed in the city of Austin, and all those folks that you are seeing out there are going to have to go somewhere, are they not?
Representative, with all due respect, I think the voters are going to be very unhappy to find out that even though they voted for this, that they would have to wait 3 years to get it fixed. I'm so glad that we're going to be able to have this effective September 1st of this year.
3 years for a large
That's
number
what I've
to
seen, how long in a letter that was sent out. A 3-year plan is not what most voters were hoping for.
Representative Capriglione, if you've looked at the plan, they will not be in the public spaces that you're referring to that have been such a problem for people. They will not be there, but they will have to go somewhere. And you cannot create 2,000 shelters overnight. It's going to take a while to do that.
Well, Representative, what I would say is if the goal now, after the voters have spoken, is to do what's inside of this bill, then I'd appreciate your support on the bill.
I'm sorry, I can't hear you.
Then I would appreciate your support on the bill.
Well, I would appreciate your looking at perhaps putting more money into the budget for helping our communities throughout the state so that they can provide the shelters that are necessary with wraparound services. Thank you.
Thank you. Mr. Speaker, members, thank you for the opportunity to again present this bill to you. It is time to vote. I move passage.
The question occurs in passing the resolution HB 1925. A record has been requested by Mr. Biederman. The clerk will read the bill. Show Mr. Capriglione voting aye. Show Mr. Harless voting aye. All members voting. All members voting. Show Mr. Schofield voting aye. There being 85 ayes, 56 nays, HB 1925 is passed in engrossment. The chair lays out on second reading HB 492. The clerk will read the bill.
HB 492 by Wu, relating to a prohibition on the issuance of a warrant authorizing the use of a no-knock entry by a peace officer.
The chair recognizes Mr. Wu to explain the bill.
Thank you. Mr. Speaker, members, this is the no-knock warrant bill. This is the way I laid it out in committee. Texas is a stand your ground state. Texas is a state that follows the castle doctrine. And essentially what that means is that once you're inside your house, you don't have to retreat any further. That if someone is about to breach your home and you're scared for your life, you can defend yourself with lethal force. That constraint, that idea directly conflicts with the idea of police ramming into your house unannounced. Because a homeowner does not know when they can adequately defend themselves. This situation, this conflict, has led to some unfortunate situations, especially in Houston, in Harris County, where no-knock warrants were issued, resulted in the deaths of innocent civilians and the permanent injury, the permanent lifelong injury of an officer. What I'm doing with this bill is very simple. One, as a general rule, no-knock warrants are banned. However, we are carving a small exception. And what the exception will be is that if the chief law enforcement officer of your agency signs off on the warrant and approves it, and you take it to a district court judge, that will be now permissible. And I do have an amendment to add in stuff that makes the bill comply with what we agreed to. Unfortunately, because of a mistake in our office, we voted out the wrong substitute and voted out a version prior to our agreement. So, and I'll discuss the amendment in a second.
The following amendment, the clerk read the amendment.
Amendment by Wu.
The chair recognizes Mr. Wu to explain the amendment.
Thank you, Mr. Speaker. The amendment puts the bill back to what our agreement with law enforcement was, and that is that the people who will be responsible for approving the no-knock warrant will be either the head of the agency, a chief of police, a sheriff, a commissioner, a director, or their direct designee, someone that works in the chief's office. That's the first thing. The second thing is that we are also allowing the warrants to be issued by both district courts and county courts at law. This will help spread out the amount of work and for smaller counties that may not have an easy access to a district court. Lastly, we're incorporating some very good common sense amendments from Representative Crockett, who helped with this bill. It adds that the no-knock warrants, the statement from the chief needs to say that we need to issue a no-knock warrant in order to protect lives. Very simple, very common sense. And the warrant would also require that, one, law enforcement officers who are conducting the raid need to be in uniform or adequately uniformed so that people know that they're police officers and they're not just in street clothes with nothing else. The last thing is that a requirement that if the agency has access to body cams, that they be turned on and used during the raid. That's it. Very common sense, and it doesn't put a burden on anyone. And with that, it is acceptable with the author, and I...
Mr. King, for what purpose?
Mr. Speaker, will the gentleman yield for a couple questions?
Will the gentleman yield for questions?
Absolutely.
The gentleman yields.
Thank you. And so essentially, on a no-knock warrant now, which is simply where you're going to serve a search warrant, an arrest warrant, and you're required to bang on the door and say, police, sheriff's department, whatever it is, before you come in, so they know who's coming in, that it's not a bad guy coming in to rob their drugs or whatever. And so now, before they can do that, they simply have to get the sheriff or the chief or their designee to approve that in advance as their senior supervisor on that.
Correct.
They have to affirm that there is the chief will have to determine that there is a significant risk of life or injury if they do not go in without announcing themselves in advance.
Correct.
They're going to take that to a district judge or county court at law judge. And for us kind of more rural folks who might have multi-county jurisdictions, if the nearest district judge is 3 counties away, they'll still be able to do that electronically.
Correct.
Even if they got to do it in the middle of the night.
Yes, we added in the electronic warrant service back like 2 or 3 sessions ago.
Right. And police officers, sheriff's deputies, whoever it is, they're simply going to have a uniform on or a big windbreaker that says police
Absolutely.
Across it where anybody can see that.
Right.
And beyond that, that's really the only restrictions in this. So you're just adding some supervision, a little more judicial oversight. You've still expanded the group of judges. Do I understand it correctly?
Yes, absolutely. And the point of the bill is to express the seriousness of which we want to impart on this type of action, but not take away a tool if they really need to use it.
And good agencies like even my little smaller town of Weatherford, They have checklists, risk assessments before doing any search warrants. So you're really just putting best practices in, correct?
Absolutely. And I'll tell you this bill reflects what the Houston Police Department has done since the tragic incident. And in the 2 years that this policy that is reflected in this bill, 2 years that this was in place, they have issued 0.
And are you aware that I've checked with a couple of my sheriffs and one of my police chiefs, and they've said that the way you've drafted it, they're very pleased with. It's best practices.
Yes.
So thank you. You've done a great job on it.
Move adoption.
Mr. Wu sent an amendment. The amendment is acceptably authored. Objection to the author's amendment. Chair hears none. The amendment is adopted. The following amendment, the clerk read the amendment.
Amendment by Crockett.
The chair recognizes Ms. Crockett to explain the amendment.
Members, I must say that I filed this amendment 12 hours, I believe is the rule, in advance of this being heard. I was significantly concerned about no-knocks. I have worked the majority of this session on no-knocks, and I was concerned that this bill did not go far enough. In the Republican platform, number 125, it says that Texas Republicans should move to make sure that we significantly limit the use of no-knocks. I stand here before you to say thank you, Representative Wu, because there were so many conditions that were not included in this bill that in a separate bill I had drafted. I sat down with the stakeholders being the families of James Reed of Killeen, who was killed, the attorney for Mr. and Mrs. Price in Fort Worth, the family of Marvin Guy, the family of James Darden in Fort Worth. We also have to remember the lives of Regina Nicholas and Dennis Tuttle of Houston and Vincent Hall of Arlington. We lost officers Chuck Dinwiddie of Killeen, Officer Bobby Hornsby of Killeen, Deputy Adam Sowers of Burleson County. We lost them as they were trying to do service for us. I drafted this amendment to make sure that we address the fact that we needed to, number one, only go into someone's home if there was a concern as to the safety of an officer. We should not be going into a home for narcotics-only raids. The majority of the raids that go wrong, they go wrong because there's a CI that says, hey, you should go in, there's drugs. What we wanted to do was build in additional protections because the Fourth Amendment provides that we should be protected from unreasonable seizures in our homes. So we did that. We also made sure that we were going to change who it was that was going to be allowed to sign off on these warrants. A lot of the things that Representative Wu has now incorporated, they did come from the amendment that we filed. The only thing that honestly is missing from the amendment is there was a concern in speaking with all law enforcement. There was a concern about the judges. And so we expanded the ability for law enforcement to actually be able to speak with a magistrate that was in a contiguous county if they needed to get to one of them. Other than that, the majority of the other procedures that we were looking for as far as making sure that there's body cams, that's in here now. But we didn't have that, and that's why advocates were here earlier today asking that you support the Crockett Amendment, because we needed a very strong bill. So with that, Mr. King, do you have questions?
We'll let you yield for a question.
Mr. King, for what purpose?
A couple of questions, if she'll yield.
Will the gentlelady yield for questions?
Yes.
She yields.
So is yours a full floor substitute to this, or are you pulling this down?
It actually was a full floor substitute, only because none of these provisions were in there. And you and I both had talked. I have your handwritten notes, and the majority of what you actually wrote is in here.
So what are you adding? I'm sorry, I'm a little bit
The only thing
confused.
that's missing now has to do with, we've got the particulars that we sat down and talked about. It says the amount of time that a body cam has to be on. It says 15 minutes after each person at the building or place has been secured, if appropriate. It's a lot more detailed, and the biggest difference that I think potentially would be objectionable just has to do with the magistrate. It says a magistrate who is not an attorney licensed by this state may issue a warrant under this chapter that authorizes a no-knock entry only if the applicant in the complaint presented to the magistrate states that the applicant attempted and failed to locate a magistrate described by subsection B1. That was kind of a big deal for the Sheriff's Association specifically. It wasn't as big a deal for TMPA and CLEAT and some of the others.
So the only things you're doing are putting in that if they've got body cams, they have to turn them on 15 minutes before and 15 minutes after?
That they, not that they have to activate them 15 minutes before, but they must leave them on
Throughout the event.
throughout the event, just so that we can be clear exactly what happens.
And then you're saying in the rural counties where they may not be able to find a district judge or county court of law judge, they could go to another magistrate who is an attorney?
They can.
Okay,
And
so
if
that's
they
good.
can't find one of them, they actually can basically just put that they made the attempt.
And they could go to a non-attorney magistrate for
Magistrate,
the
yes.
warrant?
Under those circumstances, yes.
Okay. And what else are you adding in besides those two things?
Besides that, we talked about the contiguous county issue, and I apologize. We talked about the contiguous counties, and that's pretty much it, based on the quick review of the amendment that Wu filed.
Okay, so like, pretty much it or it is it? I'm sorry, I just want to be real specific here.
So I only got to review it very quickly because that amendment was only recently filed. But essentially there's only about 2 or 3 additional things. So I would not have filed this for substitute had I seen that previously. I will tell you that.
So are you withdrawing this amendment or are you?
Only because I made agreements to the sheriffs and some others. But either way, I am going to support this bill.
Okay, I'm sorry, I'm just confused. Are you withdrawing the amendment or are you going forward with it?
No, we're just
Withdrawing the amendment.
no.
Withdrawing
I guess
the amendment means you're not going to have make people vote on it.
Just to vote. Either way, I'm going to vote. Withdrawing the amendment.
Sorry. I'm sorry, I'm just asking, are you withdrawing the amendment or are you going to ask us to vote for it? Or is it acceptable to the author?
It's not acceptable. It's not acceptable.
It's not acceptable.
Okay, thank you.
Okay, well, I won't.
The chair recognizes Mr. Wu to speak against the amendment. The amendment is withdrawn. Any member wish to speak for, against, or on the bill? The chair recognizes Mr. Wu to close on the bill.
Thank you very much, Mr. Speaker. Members, as you can see, there's been a lot of negotiations, not a lot of work on this. I really appreciate the work from Representative Crockett. She's been instrumental in helping making sure this happened. All the police associations, civil liberties groups, everybody had their input. Does this bill go as far as some people want? No. Does this bill do more than some other people want? Yes. So we're in a middle position of a compromise, and that's the best way to go. And with that, I move passage.
The question occurs in passing the engrossment of HB 492. A record of vote has been requested by Mr. Biederman. The clerk will ring the bell. Show Mr. Wu voting aye. Show Mr. Huberty voting aye. Show Mr. Kraus voting aye. Show Ms. Slauson voting aye. Show Mr. Harless voting aye. All members voting. There being 134 ayes, 7 nays, HB 492 is passed the engrossment. The chair lays out on second reading HB 1280. The clerk will read the bill.
HB 1280 by Capriglione, relating to prohibition of abortion, providing a civil penalty, creating a criminal offense.
The chair recognizes Mr. Capriglione to explain the bill.
Thank you, Mr. Speaker, members. Thank you for the opportunity to address the body today. Today, I'm here to speak to you about House Bill 1280, which enacts a complete ban on abortion that will go into effect if the United States Supreme Court wholly or partly reverses its precedent preventing states from banning abortion. While we have never repealed our pre-Roe v. Wade abortion prohibition statutes, a non-binding Fifth Circuit Court of Appeals opinion suggests that the legislature has effectively repealed the pre-Roe statutes by passing laws that govern abortions on minors, by regulating abortion facilities, and banning state funding for abortions in Medicaid. If the Supreme Court changes its precedent and allows states to protect unborn children, Texas needs a law to ban abortion to the extent allowable under the new precedent. In House Bill 1280, performing an abortion is a second-degree felony unless the unborn child dies, then it is a first degree. The person performing the abortion is also subject to a civil penalty of not less than $100,000 for each violation. Members, I've been asked a few questions about this. I'm more than happy to take any questions.
Mr. Turner, for what purpose?
The gentleman yield for some questions.
The gentleman yield for questions.
I do.
The gentleman yields.
Thank you. So, Representative Capriglione, this bill is basically a prospective bill. Is that right? I mean, it's saying if there is a future Supreme Court decision, then we'll have a new statute on the books in Texas. Is that essentially?
That's right. I guess we call it a contingency mechanism, but it's prospective on the basis of a future.
How many other issues have we done that for? Other subject matters have we done that for in the legislature, where we pass a bill and say if the Supreme Court does this someday, then we'll have this law in effect? When have we done that before?
So there's nothing novel or unusual about Texas providing a law that will go into effect upon a future contingent event. This is done in a variety of different contexts. Texas, for example, has made statutes that take effect. We've done it in the budget just recently, but also upon identifying and securing adequate state funding, on federal funding, or both. We've done it based upon the concurrence of other states, in terms of ratifications, or the concurrence of other states and the federal government. Sometimes we do it upon the enactment of federal law, authorizing imposition of a sales tax on remote sales, for instance, that we just recently did. In addition, Texas has made certain provisions of criminal laws that take effect upon a future contingent event, which is the case under the Texas Controlled Substance Act, which automatically adopts the classification or reclassification of drugs by the Attorney General of the United States under the Federal Controlled Substances. Now, none of this involves an improper delegation of legislative authority under Article 2 or Article 3, Section 1 of the Texas Constitution. I'll also point out that more than 90 years ago, the Texas Supreme Court noted, quote, "The authorities hold that while the legislature may not delegate its power to make a law, it may enact a law to become operative upon a certain contingency or future event."
Okay, thank you for that answer. I think those are interesting examples. I don't think they're a good parallel, though. I think, yes, we certainly pass laws that say, yes, if Congress takes certain action or if these funds become available in the budget, yes, that is standard operating procedure around here. But I didn't hear in that lengthy list of examples where you cite an example of where we passed a law that said if the United States Supreme Court does this, then we'll have this law in effect. So there's not another example where we passed a law based on a future hypothetical Supreme Court ruling.
Well, what I would say is that, the precedent, if you will, is broader than that. So again, the authorities hold, and this is the Texas Supreme Court, the authorities hold that while the legislature may not delegate its power to make a law, it may enact a law to become operative upon a certain contingency or future event. They did not say except for a Supreme Court ruling.
Okay. So let me ask you this, Representative Capriglione. Do you expect there to be a ruling overturning Roe v. Wade before the 2023 legislative session?
I'm personally hopeful and optimistic that There are a lot of cases headed towards the court right now. I think someone had told me, so I'd have to verify it, but somewhere around 63, 64 cases related to abortion, prohibition of abortion in different various ways that are, through different courts, appeals courts, headed their way to the Supreme Court. I do think, if you go back, it seems like a long time ago, but in November, and even right before November, the whole entire country had a conversation about the Supreme Court, picking the Supreme Court nominees, and why it was important for that to happen either before or after the election, right? I mean, we can all remember
I recall that,
all of that case. And so I think the expectation for a lot of voters at that time, I mean, to some extent, I think is accurate.
So it's possible.
I think it's absolutely possible. I think a lot.
I
I do think it's
just
possible.
as you hope it does, I hope it does not happen. But my question, Representative, is if it happens, if you get your wish and the Supreme Court overturns Roe v. Wade, do we have some reason to believe that Governor Abbott would not call the legislature back into a special session to address this? My guess is he would, based on his public comments on this subject matter. Is there a reason that we would take away the ability of the governor and the legislature to have a special session, if that's what the governor wants to do, to debate this very important issue at this time? Why are we closing off that possibility for ourselves?
Well, I think with this, the point of this bill and the point of a contingency is so that wouldn't have to happen. We, the legislature, would be able to say this is the law without requiring a special session. And I hope to God, and I know we all do, that we don't deal with the same situation that we just dealt with over the past year with the pandemic, but in some cases we may not be able to meet in a ready way. It might become something that becomes difficult to meet in a special session for other reasons. Maybe there's other legislation or other things that could prevent that from happening. But at the end of the day, we're here now, right, Representative Turner? And I think on some other things, we agree that the legislature should absolutely work on legislation, should work on laws, because we're here now. And so that's what this bill does. It says we're here now.
So let me shift gears a little bit and ask you about the penalties in the bill. And you laid it out, but
I'm sorry. Can you say that again?
The penalties in the bill. So
yes.
So if this law becomes effective, so it makes it a second-degree felony for an individuals that knowingly perform, induce, or attempt abortion, right?
That's right.
And then if the fetus does not survive the procedure, then it's a first-degree felony.
Well, and by not surviving
right?
the procedure, I think what we say and what the point is, if the child is killed.
Right. So what are some other second-degree felonies that we have on the books in Texas?
I'm not advised on all of the second degree, but I would assume
just an example or two.
Attempted murder.
Attempted murder. Okay. Any others?
I'm sorry, I don't have a list of all the second degree felonies here.
So a medical.
What I would say is that's what we're putting in this bill.
So an established medical procedure would suddenly be on the same legal footing as attempted murder.
I'm sorry?
Your bill would make an established, safe medical procedure on the same legal footing as attempted murder.
If you go back to what the point of this bill is, what the Supreme Court has done is it ruled that states can decide that states would be able to prohibit abortion. And so what we're making a second-degree felony is an attempt by someone to murder a child.
And is there any, we had discussed a bill earlier today about the point in a pregnancy in which an abortion would be legal or illegal. Does your bill make any such distinction?
It
in
does
terms of the time
provide
frame?
a little bit of a difference in terms of, for instance, if there's a reasonable risk, life-threatening physical condition aggravated or caused by or arising from a pregnancy that places the female at the risk of death.
Okay. Is there an exception if a woman has been a victim of rape or incest?
there is not that exception. What I would say, Mr. Chairman, is that in the rare cases of rape and incest, the right response, I think all would agree that the right response is compassion for both the mother and the innocent unborn child. And quite frankly, executing an innocent child for someone else's crime is not justice.
All right. So you said rare, and we hope those crimes are rare, but you would acknowledge women are victims of rape and incest in the state of Texas.
I'm sorry, I can't hear you.
I said while they may be rare, and we hope that they are rare, you do agree that at times women have been and continue to be victims of rape and incest in the state of Texas.
Yes.
That is a crime that will unfortunately continue to happen, most likely.
I hope not, but yes.
Well, I hope not either. But your bill doesn't provide any exception for a victim in that circumstance.
It does. What we're trying to do is we're protecting the child.
You're trying to protect the child.
What we want, of course, is to
regardless
arrest,
of the impact on the woman who has been raped,
the offender. But we want to be able to help, in those cases, as much as we can, the woman who is sexually assaulted. But we also want for the child to live.
Thank you.
The following amendment, the clerk read the amendment.
Amendment by Slayton.
The chair recognizes Mr. Slayton to explain the amendment.
Members, this amendment is a very simple amendment. If you intend on voting yes on this bill, it'd be very easy for you to vote yes on this amendment. This amendment simply changes the timeline from, well, let me just say this. If you plan on voting on this bill and you want to save life in the womb, date uncertain, next year, 5 years, 10, 15, 20 years from now, all this bill does is speed up the timeline, and we would save life in the womb this year.
Mr. Speaker.
Mr. Moody, for what purpose?
Raise a point of order against further consideration of the Slayton Amendment under Rule 11, Section 3 on the grounds that the amendment changes the original purpose of the bill.
Please bring your point of order down front. Mr. Moody raised a point of order against further consideration of the Slayton Amendment to Committee Substitute to House Bill 1280 under Rule 11, Section 3 of the House Rules on the grounds that the amendment changes the original purpose of the bill. Mr. Moody argues that the purpose of the bill is to ensure that there is no gap in state law if and when a judgment of the United States Supreme Court or an amendment to the United States Constitution authorizes states to prohibit abortion. The Slayton Amendment would make the bill's prohibition on abortion effective September 1, 2021, regardless of any court decision on constitutional amendment. The purpose of the amendment is exactly opposite of the purpose of the bill. Accordingly, the point of order is well taken and sustained. The chair recognizes Ms. Weiner to speak in opposition to the bill.
Members, I am fairly certain that I have given birth more recently than anyone else who serves in this chamber. Many of y'all have met my daughter, Lark. She's almost 3 years old now. And I'm so grateful to have her in my life. Being pregnant with her was one of the most vulnerable experiences of my entire life. Especially, as many of y'all know, I was on the campaign trail in a moment where we were all talking about maternal mortality. I was touring the hospital maternity wards, asking questions that kind of scared the other women on the tour about where the hemorrhage kits were stored and what their preeclampsia protocols were. Now, neither of those were the complication in pregnancy I had. The complication I had was called hyperemesis. Y'all probably know it more commonly as really bad morning sickness. Whoever named it morning sickness, I'm mad at them because that's a lie. For me, it was 24 hours a day. I was so sick that I vomited more than a dozen times a day. I couldn't eat anything for weeks. I lost 20 pounds. You know, at this time, my pregnancy wasn't public yet. I had folks walking up to me telling me how great I looked. And I was just like, y'all, I just want to be able to eat and be able to keep it down. It was hard. It was really hard. And there were days I woke up in the early days of this so desperately wanted pregnancy and didn't know if I could make it to the end. We've talked a lot about heartbeats today. The first time I, through a Doppler device, heard a heartbeat sound for my daughter, I didn't enjoy that moment. I was trying not to vomit from the pressure of that device on my stomach. I bring this up because especially having that type of complication, being on the edge of hospitalization, being so weak, it was all I could do to get myself from the bed to the bathroom. Knowing abortion was available in the state of Texas made me feel safer. It made me feel safer to know that I had options.
Members, please take your conversations outside the chamber.
It made me feel safer to know that I had options if the hyperemesis got worse, if I reached the point where I couldn't keep fluids down. And I know this isn't something folks are particularly familiar with, but this is a condition that used to kill women. Charlotte Bronte being a notable name. And again, abortion being accessible made me feel safer and made me more certain that I was going to get to the end and that I could find a path and that I had choices if something else went wrong. And luckily I got through that and enjoy my wonderful daughter today. Part of why I bring this up is when we heard this bill and others in the Public Health Committee, we heard the story of a woman who was already a mother, caring for a toddler, who was pregnant and had horrible hyperemesis and had to make the choice between being able to get out of bed and take care of her toddler or continue the pregnancy. That woman made the choice to take care of that child who had already been born despite her illness. She made the choice to have an abortion so she could take care of that baby. Members, as the member who has most recently had a baby in this building, I get asked by y'all all the time when the next one's coming. And there won't be a next one for me because I was so sick, and I know if I get that sick again, I will be in that position. That's what that choice means to women in this building. Everyone's abortion story is different. Every single one of them. And every one of us in this room has a different standard for what we believe constitutes an ethical and moral decision to have an abortion. But instead of trusting women to know their own circumstances, their families, and their own values, this bill makes the government the final arbiter of individual and intimate morality. Members, is trusting women really that unthinkable? We know what our families need. We know what we need. This bill would force a woman to carry a pregnancy that resulted from rape to term. Now, there are some women that is the right choice for, but there are some women who are going to struggle to wake up every morning and have the evidence of a horrible assault on their body. Members, this bill would force a woman whose fetus had been diagnosed with a severe abnormality, inconsistent with life, to carry that pregnancy to term every day, knowing that she would never get to hold that baby in her arms. And we've heard today about one of our own colleagues who made that type of choice, and it was the right choice for her. And it's not the right choice for every single woman. Do you really want to take that away? Members, this legislation would force a woman who is in such difficult circumstances because of the pregnancy that she is considering taking her own life to carry that pregnancy to term. I know we talk a lot about postpartum depression in this building, but depression during pregnancy is also a serious concern for women's health. This bill specifically carves out risk of death from self-harm from exceptions that would allow an abortion. Members, this bill would force a woman to carry a pregnancy to term if she knows she doesn't have the resources or the options or the support to care for that child. It would force her to carry that pregnancy to term if she knows that pregnancy will have permanent impacts on her health and well-being. The only exception in this is for life-saving, not debilitation. So members, I ask you why. We have a lot of conversations about abortion in this chamber, but this is the most extreme. This is taking away every option. This is saying to every woman in the state of Texas that you don't trust them to know their own circumstances and their own needs. Members, I'm 35. Unlike some of my colleagues who spoke about this earlier, I grew up taking access to abortion and birth control as well for granted. Those were obvious things to me. Some of you know, grew up pro-life, grew up believing that abortion should be illegal, and walked away from that as I realized more and more the rights that we need to have over our bodies. Members, there are women across Texas who take this right for granted right now, who take for granted that if they are pregnant in a circumstance that doesn't work with their life, who take for granted that if they become pregnant and there's a severe fetal abnormality, who take for granted that if they become pregnant from a sexual assault, that they will have access to abortion. I know there's a lot of voices in your ears right now about people advocating for this legislation and telling you why it's needed. But members, you pass this and you're going to hear the voice of women who have taken this right for granted and have realized that they have to fight for it. So I ask you to keep those voices in mind. I ask you to think of women like me in their 30s and 20s and their teens who have assumed that this is settled law. And ask yourselves, what happens if it's not? What happens next when women decide to stand up for these rights again? What happens when women across Texas say no more? Members, I urge you to oppose this bill and instead affirm your trust in the women of Texas to make their own decisions instead of passing them off to the government.
The chair recognizes Ms. Johnson of Dallas County to speak in opposition to the bill.
Thank you, Mr. Speaker. I want to address my comments not to the people of this body, because many don't listen, but I want to address my comments to all of the young women out in Texas watching tonight who are searching for words of comfort from this building. I can only imagine the fear and the anxiety that some of you feel now and that many will feel in the future. High school girls who are pressured into sex in the football parking lot, but we failed you because you don't have access to the birth control that you need. Afraid about continuing your education, but this body failed you because we refused to pass a bill last session that would have provided the resources for you to complete that high school education. Afraid about medical care, but we failed you there too because we can't seem to pass Medicaid expansion to get you access to the health care that you need. Afraid that you can't get a job so that you can provide for your child with the high school education you were not able to complete. Because we refuse to pass a minimum wage law that lets you earn a living and keeps you out of abject poverty. Afraid that you can't get a job as a single mother because we make it harder, because that employer may not have to retain you because it violates a sincerely held belief that unwed women should not be mothers. Worried about where you're going to live because we make it harder, because we refuse to address affordable housing. Worried about the child care. Who's going to take care of this little baby? Because we refuse to address the complete lack of affordable child care in this state. But I want you to know out there, that young woman afraid, unsure of what to do, that we, the Democratic women, alongside our Democratic men, will fight for you every day to address these concerns, because not only having this baby, but your life is important, and the quality of the life that you live is important, and the ability to be the mother that the state of Texas is going to force you to be is important. We understand your fear, your worries, and we share them. And we will fight with every breath in our bodies to help give you the support you need as you cope with unimaginable difficulties as a result of the bill that is about to pass. And maybe, just maybe, we could actually achieve some of these things to make your life a little easier one day. Thank you.
The chair recognizes Mr. Capriglione to close on the bill.
Thank you, Mr. Speaker, members. I actually didn't have a closing speech. And I was thinking about what to say, and for the first time in a few days, my oldest daughter called me just a few minutes ago. She's 17 now, and I was thinking about when she was 11, and I would help her with her math when I was sitting on that side, and then I was thinking about when she was born, because that's when I realized how important it was that we fight for life and that we fight for our children. And there's no day that goes by that I don't worry. Right? I have 3 daughters. That's what I do. I worry about them. So I understand a lot of what some other members are worried about and the potential situations that people get into. But this session, I've had the opportunity to work on a specific part of our budget, Article 2, where we do a lot of the things that we need to be doing to help women, to help children. We are, as a body, on our budget and in a lot of other bills, we do focus on women and we do focus on children. We focus on daycare. We focus on our public schools. So we are going to do, and we have always worked on making sure that we take care of our children. What this bill does, at the end of the day, what it does is it says that when the Supreme Court overturns, in my opinion, the worst ruling ever, but as soon as they overturn Roe v. Wade, our laws are all set. We don't have to come to a special session. We don't have to have a vote. We've made it clear that Texas is pro-life, pro-women, pro-children. We're Texans. I would appreciate your support on this bill. I move passage.
The question occurs on passing engrossment. HB 1280, record vote has been requested by Ms. Noble. The clerk will ring the bell. Show Ms. Click voting aye, Ms. Noble voting aye, Ms. Hull voting aye, Ms. Swanson voting aye, Ms. Capri-Glenn voting aye, Dr. Alderson voting aye. All members voting. All members voting. Show Mr. Harris voting aye. All members voting. There being 80 ayes, 64 nays, HB 1280 is passed on engrossment. Ms. Cole. The chair lays out on second reading HB 3131. The clerk will read the bill.
HB 3131 by Cole, relating to the information required to be included in the certificate of formation of a filing entity.
The chair recognizes Ms. Cole to explain the bill.
Thank you, Mr. Speaker. Members, House Bill 3131 is a cleanup bill. Currently, statute requires the certificate of formation to include the street address of the initial registered office and the name of the initial registered agent. Information included in the certificate of formation is forwarded to the comptroller and used to franchise tax account for taxable entities. However, because the mailing address on the certificate of formation is for the registered agent, tax information and correspondence sent by the comptroller is often not received by the taxpayer. House Bill 3131 simply adds a requirement that the formation documents filed with the Secretary of State include a preferred mailing address for the business. Move passage.
The question occurs on passing engrossment HB 3131. All in favor say aye. Opposed say nay. The ayes have it. HB 3131 is passed on engrossment. The chair lays out on second reading HB 2628. The clerk will read the bill.
HB 2628 by theory, relating to the administration and collection of motor vehicle sales and use taxes.
The chair recognizes Ms. Thury to explain the bill.
Thank you, Mr. Speaker. Members, motor vehicle taxes are due to the county tax assessor collector on the 20th working day after the date the motor vehicle is delivered to the purchaser. It has been noted that the language used in this deadline can be interpreted differently across counties and causes confusion for purchasers. Additionally, purchasers have 30 days to apply for the registration of the vehicle, which provides further confusion since the form used to pay tax is the same form used to apply for registration. Aligning these two dates will reduce confusion for purchasers and simplify the process for registration and the payment of motor vehicle taxes. House Bill 2628 seeks to remedy this situation by revising the deadlines by which motor vehicle retail sales and use taxes are due. Mr. Speaker, members, I move passage.
The question occurs in passing engrossment HB 2628. All in favor say aye. Opposed say nay. The ayes have it. HB 2628 is passed in engrossment. The chair lays out on second reading HB 3997. The clerk will read the bill.
HB 3997 by Bonner, relating to the transfer of certain functions relating to state employee leave from the state auditor to the comptroller.
The chair recognizes Dr. Bonner to explain the bill.
Thank you, Mr. Speaker and members. Under current law, the state auditor is responsible for providing uniform interpretations of state employee leave policy, while the comptroller is responsible for administrating the state's payroll and related policies. Since employee leave is functionally tied to payroll processing, this fragments the comptroller's authority regarding state employee pay. HB 3997 would transfer those interpretation functions from the state auditor's office to the comptroller. I move passage.
The question occurs in passing engrossment HB 3997. All in favor say aye. Opposed say nay. The ayes have it. HB 3997 is passed in engrossment. The chair lays out on second reading HB 3578. The clerk will read the bill.
HB 3578 by Guerra, relating to the payment methods for cigarette and tobacco product permit fees.
The chair recognizes Mr. Garrett to explain the bill.
Yes, members and Mr. Speaker, this bill was recommended by the Texas Comptroller. It amends the statute to include credit card payments as an acceptable payment method for cigarette and tobacco products and business permits. This modernizes the payment options by providing an additional convenient and common payment method. Now, I want to make real sure, I don't personally smoke, but this is going to add more money to our coffers in the state of Texas much faster, other than the other methods that are being required of these vendors at this time. The statute currently requires cigarette or tobacco permit fees to be paid for with cash, money order, or check. It excludes credit cards as an acceptable payment method. I want to thank Chairman Meyer, my colleagues in the Ways and Means Committee for supporting this bill unanimously in committee. Members, I hope you can join me in supporting this legislation. Mr. Speaker, I move passage.
The question occurs on passing engrossment HB 3578. All in favor say aye. Opposed say nay. The ayes have it. HB 3578 passed in engrossment. The chair lays out on second reading HB 2743. The clerk will read the bill.
HB 2743 by Metcalf, relating to the salary of certain employees who transfer within a state agency.
The chair recognizes Mr. Metcalf to explain the bill.
Thank you, Mr. Speaker. Members, House Bill 2743 will grant greater flexibility to state agencies to adjust the jobs classification salaries and move passage.
The question occurs on passing engrossment HB 2743. All in favor say aye. Opposed say nay. The ayes have it. HB 2743 is passed in engrossment. The chair lays out on second reading HB 3474. The clerk will read the bill.
HB 3474 by Theory, relating to motor fuel taxes.
The chair recognizes Ms. Thury to explain the bill.
Thank you, Mr. Speaker and members. The Comptroller's Office is responsible for investigating cases of potential tax fraud and ensuring that tax is paid on motor fuels transactions. Current code lacks definition for certain terms that are necessary to ensure individuals cannot unlawfully or
Mr. Case,
fraudulently.
for what purpose?
Mr. Speaker, I rise with point of order against further consideration of HB 3474 in that it violates Rule 8, Section 1B. The caption does not reflect the bill's imposition of a new fee.
Please bring your point of order down front.
Do I need to put the gavel in? Members, a point of order has been withdrawn. Chair recognizes Representative Theory.
Thank you, Mr. Speaker. Members, the Comptroller's Office is responsible for investigating cases of potential tax fraud and ensuring that taxes are paid on motor fuel transactions. This bill clarifies the current definitions, and that's what it does. Members, I move passage, Mr. Speaker.
The question occurs on passage to engrossment of House Bill 3474. All those in favor say aye. All those opposed say nay. The ayes have it. HB 3474 is passed to engrossment.
The chair lays out on second reading HB 3134. The clerk will read the bill.
HB 3134 by Cole, relating to the methods by which the Comptroller may provide notice of hearing to suspend a permit or license.
The chair recognizes Ms. Cole to explain the bill.
Thank you, Speaker. Members, this is another Comptroller cleanup bill relating to the methods by which the Comptroller may provide notice of a hearing on the revocation or suspension or the revocation of a suspension of a permit or license. There is an amendment.
The following amendment, the clerk will read the amendment.
Amendment by Biederman.
The chair recognizes Mr. Biederman to explain the amendment.
Yes, this amendment just gives the holder of a permit or the license the option to opt in to receiving electronic notices. I believe it's acceptably authored, and I move adoption.
Mr. Biederman submitted an amendment. The amendment is acceptably authored. Objection to the amendment. Chair hears none. The amendment is adopted. The chair recognizes Ms. Cole to close on the bill.
Move passage.
The question occurs on final passage of HB 3134. All in favor say aye. Question occurs on passing the engrossment of HB 3134. All in favor say aye. Opposed say nay. The ayes have it. HB 3134 is passed in engrossment. The chair lays out on second reading HB 2287. The clerk will read the bill.
HB 2287 by Thompson Harris, relating to data collection by and consultation with the Collaborative Task Force on Public School Mental Health Services regarding the task force duties and requiring the Texas Education Agency to report on mental health services provided to public students.
The chair recognizes Ms. Thompson to explain the bill.
Mr. Speaker, member, this has allowed TEA Collaborative Task Force on School Mental Health to collect additional data and necessary data to better evaluate the effectiveness of school mental health programs.
The following amendment, the clerk will read the amendment.
Amendment by Lamont.
The chair recognizes Mr. Lamont to explain his amendment about high-speed rail.
Thank you, Mr. Speaker. Members, this is just an amendment that ensures transparency. I appreciate Ms. T working with me on this amendment.
Mr. Lamont says an amendment. The amendment is acceptably authored. The objection to the amendment. The chair hears none. The amendment is adopted. The chair recognizes Ms. Thompson. Following amendment, the clerk will read the amendment.
Amendment by Lamont.
The chair recognizes Mr. Lamont to explain his amendment.
Thank you, Mr. Speaker. Members, this amendment includes an additional reporting requirement. I believe it's acceptable to the author.
Mr. Lamont says an amendment. The amendment is acceptably authored. The objection to adoption. The amendment. The chair hears none. The amendment is adopted. The chair recognizes Ms. Thompson to close on the bill.
Move passage.
The question occurs on passing the engrossment of HB 2287. All in favor say aye. All opposed say nay. The ayes have it. HB 2287 is passed in engrossment. The chair lays out on the second reading HB 2954. The clerk will read the bill.
HB 2954 by Thompson Harris, relating to suicide prevention, intervention, and postvention program for certain public elementary school campuses.
The chair recognizes Ms. Thompson to explain the bill.
Mr. Speaker, member, this is an optional program that will create a suicidal prevention, intervention, and a post-intervention program to assist school districts affected by incidents of suicide among elementary students.
Following amendment, the clerk will read the amendment.
Amendment by Lamont.
The chair recognizes Mr. Lamont to explain the amendment.
Thank you, Mr. Speaker. Members, this amendment protects parental rights. Move adoption.
Mr. Lamont says an amendment. The amendment is acceptably authored. The objection to the amendment. Chair hears none. The amendment is adopted. The chair recognizes Ms. Thompson to close on the bill.
Move passage.
The question occurs on passing the engrossment of HB 2954. All in favor say aye. Opposed say nay. The ayes have it. HB 2954 is passed in engrossment. Members, the next bill on the calendar is HB 3520. The Senate companion is over and eligible. The chair lays out on second reading SB 315. The clerk will read the bill.
SB 315 by Huffman, relating to restrictions on the age of a person employed by or allowed on the premises of a sexually oriented business creating a criminal offense.
The chair recognizes Mr. Hunter to explain the bill.
Thank you, Mr. Speaker. Members, this moves the age to 21 years old in sexually oriented businesses. It's an anti-human trafficking bill. I move passage.
The question occurs on passage to third reading, SB 315. All in favor say aye. Those say nay. The ayes have it. SB 315 is passed to third reading. Mr. Hunter moves to lay House Bill 3520 on the table and subject to call. The objection, chair hears none, so ordered. The chair lays out on second reading HB 1348. The clerk will read the bill.
HB 1348 by Desotel, relating to the applicability of certain laws to open enrollment charter schools.
The chair recognizes Mr. Desotel to explain the bill.
Thank you, Mr. Speaker. House Bill 1348 deals with charter schools and zoning. Recent experience have revealed that open enrollment charter schools are often not treated the same as school districts for purposes of zoning, permitting, code compliance, land development standards, and certain impact fees. Some cities have been denying charter schools through zoning ordinances. Some cities have required, in order to get a permit to build a charter school, you had to maybe run water lines for the city or do other expensive things unrelated to the charter school in order to get a permit. This bill has a lot of misinformation about it. We have some amendments to clarify it. The simple purpose is that charter schools are to be treated no less or no more than other ISD schools. It doesn't give them any special treatment, any special authority. It just says you treat them the same, and that's simply what the bill does.
Mr. Huberty, for what purpose? Following amendment, the clerk will read the amendment.
Amendment by Desotel.
The chair recognizes Mr. Desotel to explain the amendment.
Okay, members, this bill has to do with what's called impact fees. If you look at, there's been some misinformation, and so we want to clarify that charter schools, if they're a standalone charter school, they do not have to pay an impact fee to the city. But some information is out there that if a charter school says in a strip mall or a charter school is in a high-rise, this bill would mean that the whole high-rise building or the whole strip mall would be exempt from paying impact fees for providing services, and that's simply not true. The only way impact fees are exempted are if it's a standalone school, and that's what this amendment clarifies, because that's how ISDs are treated as standalone schools. I move adoption.
Mr. Desotel's similar amendment. The amendment is acceptable. The author's objection not the amendment. The chair hears none. The amendment is adopted. Following amendment, the clerk read the amendment.
Amendment by Desotel.
The chair recognizes Mr. Desotel to explain the amendment.
This is another clarifying amendment because some people interpreted the bill to say that an ISD is a political subdivision for the purposes of not being able to testify against or regarding a charter school application. This simply says that in this subsection, political subdivision does not include a school district, which means then now the school district has an absolute right to speak in opposition to or in support of a charter school and will not be prohibited from doing so. It's acceptable to the author.
Mr. Desotel's amendment is an objection to adoption. The amendment, chair hears none. The amendment is adopted. Following the amendment, the clerk read the amendment.
Amendment by J. Johnson of Paris.
The chair recognizes Mr. Johnson to explain the amendment.
Thank you, Mr. Speaker, and thank Chair Desotel for bringing this bill forth. As we're trying to move to bring school districts in line with charter schools, or charter schools in line with school districts. While charter schools have elected bodies, and while school districts have the ability to have eminent domain, this bill just simply clarifies that an open enrollment charter school does not have the power of eminent domain, and then this is acceptable to the author.
Mr. Johnson said the amendment is acceptable to the author. The objection to the adoption amendment. Chair hears none. Amendment is adopted. Is Mr. Anchia on the floor of the House? Is Mr. Bales on the floor of the House? The following amendment, the clerk read the amendment.
Amendment by Anchia.
The chair recognizes Mr. Bales to explain the amendment.
Mr. Speaker, members, this would add the following appropriately numbered section to the bill numbered section of bill accordingly. Removing section 12.103 of the Edging Code is repealed.
Speaker.
Mr. Huberty, for what purpose?
Would the gentleman yield?
Would the gentleman yield for questions?
I yield.
So this is an amendment that Chairman Anchia came up with, or we talked about, and I know you signed on to this, but for clarification purposes, Section 12.103C specifically deals with charter schools in the Education Code. And in that, back when it was originally adopted in 1995, Section C dealt specifically with municipalities under 20,000. And so what we were saying is that because the charter is saying, hey, we want to be treated the same as ISDs, ISDs don't have that same ability to do that. So if I'm an ISD, and I'll give you an example, I have the city of Humble within Humble ISD that is less than 15,000. A charter school wouldn't technically have to file the municipal codes while the ISD would. And so we're repealing that section. Now the charters have to file the same exact rules. So that's the reason that we've agreed. That's the reason I believe the chairman is going to accept this. And that's the reason we did that, so that we're creating parity amongst those districts. Is that correct?
That is correct.
Okay, thank you very much.
And I do believe this is acceptable to the author.
Mr. Bell sends an amendment. The amendment is acceptable to the author. Objection to the option amendment. Chair hears none. The amendment is adopted. Ms. Gonzalez, for what purpose?
I'm just waiting to see if I can ask the gentleman some questions.
The chair recognizes Mr. Destel to close on the bill. Ms. Gonzalez, for what purpose?
Would the gentleman yield?
Would the gentleman yield for questions? The gentleman yields.
Yes, sir.
Chairman
Yes,
Desautel, can you explain the difference between the governing bodies between a local ISD and a charter school?
A local ISD has a school board that's elected locally within the parameters of a certain geographical area, or a charter school does not.
How do charter school governing bodies get appointed to be the governing body for that entity?
Well, they are corporations, so they're appointed like any other corporation. Some are nonprofit, some are for-profit.
So you have corporations that are appointed that were giving what would be governmental powers to another entity.
Say that again?
So you're saying that you have a corporation, and that we're giving this corporation, using your words, powers that we really only give to an elected political subdivision. Is that accurate?
No, I wouldn't agree with that. The state of Texas gave them the powers to be a school that we recognize as a public school. That's where they get the authority from.
But when
from
we
us,
think
the
about,
legislature.
excuse me, I'm so sorry. When we think about governing bodies, and we think about governing bodies exist to create accountability and transparency, does that seem fair?
That seems fair, but this, as I just stated, the authority comes from the legislature, not, it's the way we set it up. we certainly have the power to change that, but not in this bill.
But do you maybe feel that because through your piece of legislation, we could potentially be taking away a layer of both local control and transparency and accountability?
No, I do not think that they're doing that at all. I think it's just putting a public school that we declared to be a public school on parity with other public schools. That's all. It doesn't give it any additional authority that other schools don't have.
But isn't there a question around how do you hold, you're giving extra powers to an entity that does not have an elected presence. Is that accurate?
That is not accurate. We're not giving them extra powers. They have the same authority as the independent school districts per the Texas legislature. Some cities, though, are choosing to use zoning as a way to keep charters out of a particular area if they don't particularly like charters for whatever reason.
But if you're not giving them extra power, what does your bill do then?
Gives them the same authority, equal as independent school districts.
But they don't have the same governing bodies.
We're not talking about strip malls. We're not talking about.
But they don't give them this. But we're not talking about the same governing bodies, the same level of accountability and transparency for the public. Is that accurate?
They don't have none of them have the same governing body. No independent school district has the same as another. Where they get their authority from is the state legislature. We gave them that authority.
But you, in your first question, said that this is a corporation, that these are corporations, both sometimes for-profit and nonprofit, that we're giving extra authority to, that we give to local ISDs who have an elected body. Is that accurate?
I think if you want to change the structure, you'd have to change it in the legislature, but not through a zoning or land use bill.
I appreciate you answering my questions. I really appreciate your leadership. As you know, I'm voting no on this piece of legislation, but thank you for entertaining the questions today.
No, thank you.
Mr. Huberty, for what purpose?
Will the gentleman yield, please?
Will the gentleman yield?
Yes.
The gentleman yield.
Chairman, thank you very much. Okay, let's get back actually what this bill does. Okay? So
Yes.
I appreciate Chairwoman Gonzalez and what she was getting at, but that has nothing to do with what this bill does.
That's correct.
Okay, this bill simply seeks parity, the same treatment for both schools, districts, and charter schools. Is that correct?
That's correct.
Okay, and so we're not asking for any special treatment, preferential treatment for charter schools. Instead, we're working to ensure that governments treat ISDs and charter schools the same. Is that not correct?
That's all it does.
Specifically related to zoning issues as we build new schools. For example, there is an example of a school district, a charter school wanting to build in a municipality that is being built as an example. And so in order to get approval, they made the charter school put in a $400,000 pipeline that they wouldn't have made the ISD put in. Would that be a fair assessment?
That's one of the reasons we're bringing the bill for those types of examples.
And there's another example where in January 2016, the Dallas City Council narrowly approved for Uplift Education to open a new campus. And the meeting was, very close, a lot of opposition. And one of the trustees has since campaigned on moratoriums for charters. They just don't like charters, so they're doing everything they can to try to stop them. Is that right?
Some municipalities are doing that. Yes.
Are charter schools public schools in the state of Texas?
They are public schools in the state of Texas.
And are charter schools mostly in the urban areas where we've had problems with our school districts, where we've seen that? Is that a fair assessment of where the majority
that was the purpose that the legislature developed the charter schools.
So why are we trying to get parity for the schools and the ISDs? I mean, what's the goal? We're trying to get the same level of zoning so that they are able to do that. Is that correct?
That's all we're trying to do.
All right,
yes.
so that's what this bill actually does. Is that correct?
That's correct,
All right,
yes.
thank you, Mr. Chairman.
Move passage.
The question occurs in passing of engrossment HB 1348. The record of vote has been requested by Mr. Kaysen. The clerk will ring the bell. Show Mr. Destel voting aye. So Mr. Dutton voting aye. So Mr. Schaefer voting aye. So Mr. Elzey voting aye. So Mr. Lamont voting aye. All members voting. So Mr. Leach voting aye. All members voting. There being 66 ayes, 72 nays, House Bill 1348 fails to pass the engrossment.
Mr. Speaker.
Mr. Doorkeeper.
Mr. Speaker, I have a messenger from the Senate at the door of the House.
Admit the messenger.
Thank you, Mr. Speaker. I'm directed by the Senate to inform the House that the Senate has taken the following action.
The chair lays out on second reading HB 3615. The clerk will read the bill.
HB 3615 by Kinga Parker relating to chilled water service and district cooling systems.
The chair recognizes Mr. Parker to explain the bill.
That's 5 times.
The chair recognizes Mr. King of Parker to explain the bill.
Thank you. Only 22 years here, that's okay. If I got to be called someone, Tan's okay. Members, everything in government should be transparent unless there's a really compelling and clearly legal reason to keep it secret. This bill simply amends the Public Utility Code to clarify that a municipal utility that operates a chilled water system within that electric municipal utility, and there's only one in the state, that they have to make their revenues and their costs that go into that, the accounting for that chilled water system, that they have to make that public so that the ratepayers can take that into consideration and when they're doing their rate cases. And again, this would only apply to one municipal utility in the state, which, as you can tell from Ms. Donna at the back, is Austin Electric.
Ms. Howard.
Yes, Mr. Speaker, would the gentleman yield?
Would the gentleman yield for questions?
Absolutely.
Yes, this does just apply to Austin Energy. President King, I know we talked about this when it came up in State Affairs, and the way that I think you're portraying it is as if this were a part of the utility, but it is a separate service that no one's required to participate in. It's a service that you can purchase if you want to. You can put in your own HVAC system. You could get, if someone else came in and did a chilling plant, you could use that. The Capitol has its own. The University of Texas has its own. Is that not correct?
No, it's not. It's
Okay.
It's not, for example, part of the water utility. It's not part of any city services. It is part of the municipal electric utility. And everything within that electric utility, in fact, this is used to reduce off-peak hours demand. It's used to help reduce the demand for electricity that would otherwise be needed in cooling the large skyscrapers and such downtown. So it is part of the electric utility. So the way I would describe it is, members, if you look at this big room right here and pretend that this is the offices of Austin Electric, and everything's clear and apparent, and you can see where all the monies are being spent, where the monies are being collected, but there's this one room over there, kind of where the lounge is. And that room has no windows, and it's got a door with a lock on it. And the public gets to see everything that's going on with money within this big room, so they know how it's being spent and how it figures into their rates. But they can't see what's going on in that room. And all this bill does is unlock the door and let the public see the revenues that are coming in and the expenses that are going out, so that they can calculate that in and then use that to maybe save money for the ratepayers in the rate cases, because we really don't know where the money is going. Now, I'll say this, they do a great job with that chilled water system. It's a wonderful service, and they do a good job with it, but they need to have a public accounting.
Well, I do appreciate your meeting with me and my office and trying to look at how we could make this better for what we're looking at here. But, you know, I have to ask you, do you represent Austin?
Well, I do. In fact, there's an Attorney General's opinion that says, you know, every person in the state of Texas is your constituent and my constituent.
So now I understand, though, that's why everybody here is always doing bills about Austin? Because you actually represent Austin?
It applies to every municipal utility in the state of Texas that operates a chilled water system. So far, that's
but
only.
that's just Austin. That's just Austin
So
Energy
far,
you're
that is
talking
correct.
about.
San
So-
Antonio has one, but it's under SAWS, and they make that information public, as I understand.
So we talked about making this information public and doing it through the Public Information Act as opposed to putting it before the PUC. This is a separate thing, separate and apart. I know you're claiming that it's not, but it is separate and apart from our utilities. You do not have to use this chilling system. You can put your own HVAC system in. As I said, you could buy from somebody else if they had it. So do you know, does the money that Austin Energy makes in the district cooling go back to the city of Austin?
We don't know.
No, they actually testified, no. The general fund transfer is calculated on the net revenue of Austin Energy, which does not include revenue from district cooling. Did you hear that when they testified?
They told us is that that money stays within the municipal utility.
Right.
But that's not our point. Our point is that money should be calculated in to the rate cases when they go before the Public Utility Commission, because it is either expenses or profit that should be used to offset or explain the rates that are being charged when we have a rate case.
If the intention here is transparency, why bring in the PUC when we've talked about having a mechanism for getting the information through Public Information Act? Why does it need to be part of the PUC?
Great question, because the way the rate cases work for the city of Austin and really any municipal utility, so first a ratepayer, you at your home or an office building downtown, first they appeal that to the city. And then if they're not satisfied with it, it can be taken on to the Public Utility Commission. And this would allow, if the Public Utility Commission hears those rate cases, it would allow them to have all the information of all the revenues and expenses that are going on in this big room and everything that's going on behind the locked door.
So I understand that when we talked with Representative Button that there were concerns from her community that they would be included in this. So obviously there's something here that others don't particularly want to see as well. Is that not correct?
She has an amendment, and I'll let her lay out her amendment.
But I mean, the point of, and we'll see what the amendment says, but my point in what I'm asking you is there's concerns expressed by another community that is not Austin about the implications of this bill. Is that not correct?
I believe that Representative Button would tell you that the city of Garland, they're one of the 70 or so municipal utilities we have, that they just wanted to clarify that this doesn't apply to a municipally owned utility unless that municipally owned utility has a chilled water system. And so she's bringing a clarifying amendment just to put an underline in that so there's no confusion.
I mean, that's already in the bill, is it not?
I think it is, but she wants to clarify that so there's never any confusion.
So I guess I'll ask her as to why that's a problem, but thank you.
Thank you.
The following amendment, the clerk read the amendment.
Amendment by Button.
The chair recognizes Ms. Button to explain the amendment.
Thank you, Mr. Speaker. Members, this is just simply a clarifying amendment, and I believe it's acceptable to the author, and I move adoption.
Ms. Howard, for what purpose?
The lady yield for a question?
Will the lady yield for questions? She yields for questions.
Yes.
Thank you, Representative Button. Can you explain to me what the concern is that was brought to you by your community?
Well, it's to personally, I think that they just have a little bit of kind of want to clarify it. So it's not really a major concern, but I think they're entitled to get that clarified. And I did converse with Representative King, and he thought that would be a good idea. And we also checked with the parliamentarian, and they think it's perfectly fine that if I present this clarification amendment. Basically, this amendment simply just clarifies that the provisions of this bill apply only to a municipality owned utility or city that operates a chilled water program,
Right.
which is the focus of the Chairman King's bill. And I believe, this is just a very simple clarification, and we don't have any intent to get into your disputes or argument or debating with Representative King.
I appreciate that. What I am asking, though, is why was your community, it's Garland, I believe, that we're talking about here, is that correct?
Yes.
Why did Garland want to make sure that they were not a part of this?
Because we are just a city very, very conscientious about make sure that...
What did they think the consequence of being a part of this might be?
To me, this is very simple. But they asked me to do this to clarify it, and I do got the other two wonderful representatives. They represent a part of Garland to join me. So I think it's do something to make them feel that they don't have to worry about the confusion. It's perfectly fine.
What would it be that would worry them about being a part of this bill?
Actually, I don't have any worry.
Not you. I'm talking about Garland. What's their worry about being a part of this bill?
They just don't want to get into your argument with the Representative King. Is that right?
Okay, well, I appreciate that. Clearly, they had some concern enough to where they wanted to have an amendment that carved them out, made sure they were not covered by this, regardless of the fact that it doesn't seem like they were in the first place. But they cared enough about it. It sounds to me like you're saying, are you not, that they wanted to make sure there was an amendment that said that this did not apply to them for some reason.
Well, basically, please understand that the people from Garland, like I am, we are very, very conscientious about what we are doing. So I don't think there's really a kind of a setback or whatever to Chairman King's bill. It's very straightforward, but if we can do something, make them feel better, do it, because
somehow
we serve here.
They feel better.
That's
not
why,
be a part of this bill.
we talked about that before. Once again, we don't want to get involved with your conversation with Representative King, okay? And that's between you and him, and also about Austin. And we're just happy that we Garland we're solid, very, very strongly behind this bill. And but once again,
as long as you're not a part of it, right?
No, we don't have any problem. But to make sure that we have a transparency and clarification, I don't see anything wrong with that.
Thank you.
Thank you.
Ms. Button sends out amendment. The amendment is acceptable to the author. Objection to the opposite amendment. Chair hears none. The amendment is adopted. The chair recognizes Mr. King to close on the bill.
Thank you, Mr. Speaker. Members, this really just is about transparency. And
Mr. Speaker?
Mr. Harless, for what purpose?
Will the gentleman yield for a few questions?
The gentleman yields from the
Absolutely.
questions. He yields.
Mr. King, you're all about transparency, aren't you?
yes, sir, that's all this bill is just some added transparency, nothing more.
And so if somebody has nothing to hide, they shouldn't oppose this bill. Is that correct?
Again, everything in government should be very transparent unless there's really a compelling reason for it otherwise. And I don't think there's a justification for not opening that door for this information for the ratepayers.
Thank you, sir.
Thank you, members. Thank you very much and for a late night, and would ask for your favorable vote and move passage.
The question occurs on passing the resolution HB 3615. All in favor say aye. Say nay. The ayes have it. HB 3615 is passed in engrossment. The chair recognizes Mr. Rainey for a notice.
Pursuant to Rule 7, Section 37C, I hereby give notice that I will intend in 1 hour's time to move to reconsider the vote by which HB 1348 failed to pass to engrossment.
Members, we will take up that motion to reconsider tomorrow. The chair lays out on second reading HB 2256. The clerk will read the bill.
HB 2256 by Guerra, relating to creating a bilingual special education certification to teach students of limited English proficiency with disabilities.
The chair recognizes Mr. Garrett to explain the bill.
Thank you, Mr. Speaker. Members, HB 2256 creates a certificate in both bilingual education and special education. This is specific voluntary training in bilingual special education, which will certify a unique group of school teachers who are equipped to serve the specific linguistic, cultural, and academic needs of English learner children with disabilities and developmental delays. Members, I move passage.
The question occurs on passing the engrossment HB 2256. All in favor say aye. All opposed say nay. The ayes have it. HB 2256 is passed in engrossment. The chair lays out on second reading HB 2301. The clerk will read the bill.
HB 2301 by Parker, relating to a change of name for participants in the address confidentiality program administered by the Office of the Attorney General.
The chair recognizes Mr. Parker to explain the bill.
Thank you, Mr. Speaker and members. House Bill 2301 seeks to make it easier for survivors of human trafficking, family violence, sexual assault, or stalking to obtain a name change and further ensure their safety. It would allow individuals enrolled in the address confidentiality program to use proof of their enrollment in the program to satisfy the address and reasoning criteria when petitioning for a name change. I move passage.
The question occurs on passing the engrossment HB 2301. All in favor say aye. All opposed say nay. The ayes have it. HB 2301 is passed in engrossment. The chair lays out on second reading HB 302. The clerk will read the bill.
HB 302 by Collier, relating to the prosecution of the offense of sexual assault.
The chair recognizes Ms. Collier to explain the bill.
Thank you, Mr. Speaker. This bill updates the circumstances of consent in the Penal Code to ensure the crime of sexual assault covers situations when consent is clearly lacking. I move passage.
The question occurs on passing the engrossment HB 302. All in favor say aye. All opposed say nay. The ayes have it. HB 302 is passed in engrossment. The chair lays out on second reading HB 1824. The clerk will read the bill.
HB 1824 by Price, relating to the continuity of services received by persons receiving services at state hospitals and state-supported living centers.
The chair recognizes Mr. Price to explain the bill.
Thank you, Mr. Speaker. House Bill 1824 is about the safety and continuity of services for residents of state-supported living centers. House Bill 1824's objective is to provide expedited behavioral or mental health care for a small number of residents of a state-supported living center if deemed necessary. That small number of residents that I'm referencing are ones who experience intensive behavioral and or psychiatric needs beyond the supports available in a traditional SSLC setting. The bill allows for expeditious treatment on a very specific population. The changes provide better continuity of care, and I move passage.
The question occurs on passing the engrossment HB 1824. All in favor say aye. All opposed say nay. The ayes have it. HB 1824 is passed in engrossment.
Basically, they're
The chair lays out on second reading HB 678. The clerk will read the bill.
HB 678 by Cortez, relating to the administration of a medication, immunization, or vaccination by a pharmacist.
The chair recognizes Mr. Cortez to explain the bill.
Thank you, Mr. Speaker. Members, pharmacists and pharmacy technicians throughout Texas have played an instrumental role in the current COVID-19 pandemic response and are uniquely positioned to continue serving as active participants in the vaccination effort. House Bill 678 will increase access to immunizations by allowing pharmacists to independently order and administer all FDA-approved immunizations. I move passage.
The following amendment, the clerk will read the amendment.
Amendment by Tinderholt.
The chair recognizes Mr. Tinderholt to explain the bill.
Thank you, Mr. Speaker. Members, I'd like to thank Rep. Cortez for bringing this bill. Currently, pharmacists have an emergency authorization to administer these vaccines. However, the bill does not address the important difference between going to a pharmacist versus going to a doctor's office. Currently, code stipulates that a parent or a legal guardian or other individual legally allowed to make medical choices for a minor can provide written consent for a vaccine. When you remove the primary care physician from the equation, the child is not known by the H-E-B, Walmart, or CVS pharmacist in the way that the primary doctor knows their patient. The physical presence of the decision maker or parent guardian is important to ensure their consent, as written consent is possible for those not legally able to make those decisions for a child. This amendment rectifies the issue. I did an original amendment, which I changed after I talked to him. Basically, The pharmacist can still go to the school and do vaccine drives with the written consent. They just can't do it at the CVS store without the parent or guardian being present. I was hoping it could be the acceptance of the author, and I'm not quite sure where we are yet on that.
The chair recognizes Mr. Cortez to speak against the amendment.
Thank you, Mr. Members. Speaker, I respect Representative Tinderholt. He and I were having some good discussions about his potential amendment. However, there still would be, that amendment could potentially cause some questions in terms of pharmacies being able to partner with an independent school district, for example, to have a back-to-school vaccination fair for their students. Also, as you know, there's many mobile vaccine clinics that go into a lot of our lower income neighborhoods and provide vaccines for minorities in our community. And so this amendment, I think, would not be able to clarify that or what it is he's trying to achieve. And so I respectfully ask that you vote against the amendment.
The chair recognizes Mr. Tinderholt to close on the amendment.
Thank you, Mr. Speaker. Members, I very respectfully disagree with that. I changed my amendment to meet his intent. I specifically said a pharmacist at the pharmacist's usual place of business has to have parental consent. That means that schools can still use the written consent according to the family code that he handed me, section 32.101, where it specifically states that they can still do it with written consent. I'll give you an example. Round Rock ISD just settled with parents who had their child vaccinated, and they specifically put on the form they did not want that child to be vaccinated, and it still happened. They will still be able to do the vaccine drives in the community. Again, the amendment I changed specifically states at their routine or normal place of business, so at the CVS, not where the drives are. I move passage.
The question occurs on adoption of the amendment. Mr. Tinderholt has requested a record vote. The clerk will ring the bell. Show Mr. Tinderholt voting aye, Mr. Cortez voting nay, Ms. Hinojosa voting nay. All members voting. There being 44 ayes, 99 nays, the amendment fails to adopt. Any member wish to speak for, against, or on the bill? The chair recognizes Mr. Cortez to close on the bill.
Thank you, Mr. Speaker. I move passage.
Question occurs on passage of the resolution of HB 678. All in favor say aye. Opposed say nay. HB 678 is passed in engrossment. The chair lays out on second reading HB 4245. The clerk will read the bill.
HB 4245 by Frulo, relating to municipal registration of vacant buildings in certain municipalities.
The chair recognizes Mr. Frulo to explain the bill.
Mr. Speaker, members, HB 4245 brackets Lubbock County, so it may adopt a vacant building registration requirement. I move passage.
Question occurs on passing the resolution of HB 4245. All in favor say aye. Opposed say nay. The ayes have it. HB 4245 is passed in engrossment.
Yes, ma'am.
The chair lays out on second reading HB 2577. The clerk will read the bill.
HB 2577 by Kimball, relating to the light-duty motor vehicle purchase or lease incentive program.
The chair recognizes Mr. Kimball to explain the bill.
Thank you, Mr. Speaker. This bill simply allows low-emission electric motorcycles into the TERP program, and I believe we have an amendment.
The following amendment, the clerk will read the amendment.
Amendment by Mel Montgomery.
The chair recognizes Mr. Bell to explain the amendment.
Thank you, members. This amendment just makes sure that the full incentive goes to the individual purchasing the motorcycle. Move adoption.
Mr. Bell sends an amendment. The amendment is acceptable to the author's objection. Adoption of the amendment. Chair hears none. The amendment is adopted. Chair will recognize Mr. Kimball to close on the bill.
Thank you, Mr. Speaker. Move passage.
Question occurs on passage of engrossment HB 2577. All in favor say aye. Opposed say nay. The ayes have it. HB 2577 is passed in engrossment. The chair lays out on second reading HB 3084. The clerk will read the bill.
HB 3084 by Larson, relating to the identification of and funding for interregional water projects.
The chair recognizes Mr. Larson to explain the bill.
Thank you, Mr. Speaker. Members, oceans of water are under the canopy of the state of Texas. We need to figure out how to capture them. We've got regional planning districts, 16 of them across the state. What this is going to do is coordinate those regions and create multi-regional projects so the state of Texas will thrive with water in the next drought.
Speaker.
Mr. Raymond, for what purpose?
Gentleman, yield for a question.
The gentleman yield for questions.
I will.
Gentleman
Thank you, Mr. Speaker. Chairman, I just wanted to clarify, since I'm in Region M, I believe,
So what regions are put together? I mean, what M is with?
And Region M? Is that what you said?
I think so.
Yeah. Yeah, I think you're Region R, Raymond. I think you're good. No, there are multiple regions that are by alphabet. In the San Antonio area, it's Region L.
Yeah,
Got projects that we coordinate with all the people within that region. They're based on the basin lines, the river basin lines. The problem is we've balkanized our state within those regions, so we need to build projects that could affect several regions. That's what other states do.
So would you say this would
so we're advocating the Water Development Board get involved in this.
So this bill would debalkanize?
It would what?
Debalkanize the state?
Yeah, it could debalkanize the state. It sure could. It's good for Texas. It's good for America.
Great bill.
Thank you. Move passage, Mr. Speaker.
The question occurs on passing the engrossment HB 3084. All in favor say aye. Opposed say nay. The ayes have it. HB 3084 is passed in engrossment. Members, the next bill on the calendar is HB 3713. The Senate companion is over and eligible. The chair lays out on second reading SB 1774. The clerk will read the bill.
SB 1774 by Alvarado, in the conveyance of certain real property by certain navigation districts.
The chair recognizes Mr. Canales to explain the bill.
Mr. Speaker, members, this is the conveyance of certain real properties by navigation districts, and I move passage.
The question occurs on passage of third reading SB 1774. All in favor say aye. Opposed say nay. SB 1774 is passed in engrossment. Pass the third reading. Mr. Canales moves that HB 3713 be laid on the table subject to the call. There's objection to that motion. Chair hears none. Motion is adopted. The chair lays out on second reading HB 2535. The clerk will read the bill.
HB 2535 by Sanford, relating to the appraisal for ad valorem tax purposes of real property that include improvements used for the non-commercial production of food for personal consumption.
The chair recognizes Mr. Sanford to explain the bill.
Thank you, Mr. Speaker. This bill seeks to clarify that the use of chicken coops and rabbit pens that are used for non-commercial production of food are excluded from the market value of real property. Move passage.
The question occurs on passing the engrossment HB 2535. This is a record vote requested by Mr. Kaysen. The clerk will ring the bell. All members voting. All members voting. There being 143 ayes, 0 nays, HB 2535 is passed in engrossment. The chair lays out on second reading HB 547. The clerk will read the bill.
HB 547 by Frank, relating to authorizing equal opportunity for access by homeschool students to University Interscholastic League sponsored activities, authorizing a fee.
The chair recognizes Mr. Frank to explain the bill.
Mr. Speaker, members, there is no bill that I have spent more time on in my 8 years in the Texas House than the bill before you. House Bill 547 allows homeschoolers who want to participate in UIL activities the chance to do so. We have put protections in the bill. The homeschooler must pass standardized tests at grade levels. They have to turn in grades and follow all team guidelines. It also, members, it allows ISDs in a permissive way that want to offer the opportunity to homeschool students in their districts the ability to do so. There are many things that homeschool families can do well, but there are a few that are impossible. I can educate my children at home. I cannot provide a band, a team, or academic competitions. And while there are some homeschool families that have been able to form teams or leagues, people that are economically disadvantaged that cannot afford those teams, or people living in rural areas, or frankly anywhere outside the 4 main population centers, there is simply no alternative by the time you get to 8th grade unless you are allowed to participate in your community school. And they are community schools. Members, I know some of you have gotten calls from your district, but I firmly believe that good school districts want more kids in their school. What's that? In fact, if you look Arizona, who did this, 1 out of every 3 kids that started participating in UIL sports or UIL activities ended up going into the school system full time. At a time where many public schools have lost enrollment, I would think that good schools would be thrilled at the chance to get kids into their programs and possibly back into their classrooms. Members, I want to thank my joint authors, Chair Dutton, Dan Huberty, Dr. Gonzalez, and Dustin Burrows for their work on this. I do believe we have several amendments. And
Mr. Speaker.
Mr. King, for what purpose?
I rise to raise a point of order against further consideration of House Bill 547. Under Rule 4, Section 32B10, that the witness list is incomplete, therefore incorrect.
Please bring your point of order down front.
Point of order is withdrawn. Chair recognizes Mr. Frank for a motion.
Mr. Speaker, I move to recommit House Bill 547 to the Committee on Public Education.
Members, you've heard the motion. Is there any objections? Hearing none, the motion is adopted. Chair lays out on second reading House Bill 2581. Clerk, read the bill.
HB 2581 by Cassell, relating to civil works projects and other construction projects of governmental entities.
Chair recognizes Mr. Cassell to explain the bill.
Thank you, Mr. Speaker. Members, HB 2581, which passed out of committee, unanimously creates a fair and consistent building process that will promote competition and use taxpayer dollars more efficiently, and I move passage.
Question occurs in the passage to engrossment of House Bill 2581. All those in favor say aye. All those in favor say nay. Ayes have it. House Bill 2581 is passed to engrossment. Chair lays out on second reading House Bill 237. The clerk will read the bill.
HB 237 by Bernal, relating to student access to certain academic records, authorizing a fee.
Chair recognizes Mr. Bernal to explain the bill.
Thank you, Mr. Speaker. Members, HB 237 would allow people who owe institutions of higher learning money, if they've been out of school for 5 years, the ability to access their transcripts if they make a good faith effort, like a payment plan, to pay the money back. Move passage.
Question occurs on the passage to engrossment of House Bill 237. All those in favor say aye. All those opposed say nay. The ayes have it. House Bill 237 is passed to engrossment. Chair lays out on second reading House Bill 4272. Clerk will read the bill.
HB 4272 by Click, relating to requirements for information contained in the immunization registry.
Chair recognizes Ms. Click for a motion.
Mr. Speaker, I move to postpone further consideration of HB 4272 until 10 a.m. Thursday, May 6th.
Members, you've heard the motion. Is there any objection? Chair hears none. The motion is adopted. Chair lays out on second reading House Bill 2064. The clerk will read the bill.
HB 2064 by Leach, relating to the amount of a hospital or physician lien on certain causes of action or claims.
Chair recognizes Mr. Leach to explain the bill.
Thank you, Mr. Speaker. Members, under current law, any lien a hospital places on a cause of action or claim of an individual for services provided for injuries caused by an accident is capped under the provisions of the existing hospital lien statute. This bill will provide a third option to include whatever amount is awarded by the trier of fact for the services provided to the individual by the hospital. Members, I move passage.
Question occurs on passage to engrossment of House Bill 2064. All those in favor say aye. All those opposed say nay. The ayes have it. House Bill 2064 is passed to engrossment. Chair lays out House Bill 2327 on second reading. Clerk, read the bill.
HB 2327 by Freelow, relating to increasing the criminal penalty for operating a watercraft while intoxicated with a child passenger, changing the eligibility for deferred education and community service provision.
Chair recognizes Mr. Frulo for a motion.
Mr. Speaker, I postpone further consideration of HB 2327 to 8 a.m. June 1st.
Members, you heard the motion. Is there any objection? Chair hears none. The motion is adopted. Chair lays out on second reading House Bill 679. The clerk read the bill.
HB 679 by Griffin Hawkins, joining the standards for attorneys representing indigent defendants in certain capital felony cases.
Chair recognizes Ms. Gervin Hawkins to explain the bill.
Speaker, members, this is a great bill. What House Bill 679 does is what I call build the bench. Currently, Texas has more capital cases going through the system than we have experienced attorneys under the current system who are qualified to handle capital cases. What House Bill 679 does is allow inexperienced people to take on these trials that are only qualified defense attorneys with significant criminal experience, including experience handling homicide trials, will be eligible under this new rule. I also have an amendment, which will be a floor amendment, but what this does is build the legal bench so that capital trials can move through the system. I've also, in developing this bill, it went through Crim Juror Committee 9-0. I met with the Honorable Judge Misty Mandera from Nueces County, David Slayton, Administrative Director for the Texas Office of Court Administration, Megan Lavoie, Director of Public Affairs at the Special Counsel, Texas Office of Court Administration, Jeff Burkhart, Executive Director for Texas Indigent Defense Commission, Benjamin Wolf, Texas Indigent Defense Commission, Amanda Marzullo, Attorney, former Executive Director of the Texas Defender Service. Again, all this bill does is build the bench for capital murder cases. With that, I move passage.
Following amendment, the clerk read the amendment.
Amendment by Gervin Hawkins.
Chair recognizes Ms. Gervin Hawkins to explain the amendment.
All the amendment does is ensure that all the training is in place, so within the training and what the skill set that the attorneys must have, they must be a member of the Texas State Bar, exhibit proficiency and commitment to providing quality representation, have not been found by a federal or state court to have rendered ineffective assistance, have at least 5 years of criminal law experience, have authored a significant number of appellate briefs. So it speaks to the experience that the individual must have.
Ms.
With that, I move
Hawkins,
adoption.
Ms. Gervin Hawkins sends up an amendment. The amendment is acceptable to the authors. Any objection? Chair hearing none. Amendment is adopted. Chair recognizes Ms. Gervin Hawkins to close on the bill.
I move passage.
Question occurs to passage to engrossment of House Bill 679. All those in favor say aye. All those opposed say nay. The ayes have it. House Bill 679 is passed to engrossment. Chair lays out on second reading House Bill 2595. Clerk will read the bill.
HB 2595 by Price, relating to educational materials and parity laws training regarding benefits for mental health conditions and substance use disorders to be made available through a complaint portal and otherwise designated October's Mental Health Condition and Substance Use Disorder Parity Awareness Month.
Chair recognizes Mr. Price to explain the bill.
Thank you, Mr. Speaker. Members, in 2017, we passed House Bill 10, which created parity in the handling of insurance benefits and claims for mental health care and substance abuse disorders. This bill seeks to implement recommendations from the work group that we created in that bill. Specifically, it does 3 things. House Bill 2595 raises public awareness through educational materials, naming October as Mental Health Condition and Substance Use Disorder Parity Awareness Month. Second, it creates a complaint submission process through a portal, and it provides basic training related to parity rights. Mr. Speaker, I move passage.
Question occurs on passage to engrossment of House Bill 2595. All those in favor say aye. All those opposed say nay. The ayes have it. House Bill 2595 is passed to engrossment. Chair lays out on second reading House Bill 700. Clerk will read the bill.
HB 700 by J. Johnson and Parrish, relating to the eligibility of foster children to receive college credit for completing the preparation for adult living program.
Chair recognizes Mr. Johnson of Harris to explain the bill.
Thank you, Mr. Speaker. The Texas Higher Education Coordinating Board will establish a work group to develop a plan to ensure that foster youth who complete the standardized curriculum for preparation for adult living are eligible to receive college credit for completion of the program. The work group must include representation from urban as well as rural institution of higher education as defined in this section of the Education Code. In developing the evidence-based recommendation, the work group shall consider the feasibility of implementing each recommendation for foster youth access to the PAL program and average length of time a foster youth will remain in placement. I move passage.
Question occurs on passage to engrossment of House Bill 700. All those in favor say aye. All those opposed say nay. The ayes have it. House Bill 700 is passed to engrossment. Chair lays out on second reading House Bill 3240. Clerk, read the bill.
HB 3240 by click would edit the composition of the Long-Term Care Facilities Council and rules related to the imposition of administrative penalties against certain long-term care facilities.
Chair recognizes Ms. Click to explain the bill.
Thank you, Mr. Speaker. Members, HB 3240 cleans up 3 issues from previous sessions. It adds ICF IDD long-term care facility provider to the Long-Term Care Facilities Council. It clarifies penalty caps which can be assessed ICF IDD facilities. And finally, it requires interpretive guidelines to be developed to remove inconsistent interpretation. I do have a clarifying amendment.
Following amendment, the clerk read the amendment.
Amendment by click.
Chair recognizes Ms. Click to explain the amendment.
Members, this amendment simply removes language in Section 3 that was mistakenly amended in the committee substitute. It reverts it back to the language to the way the bill was filed. The amendment is acceptable to the offer, and I move adoption.
Ms. Click sends up an amendment. The amendment is acceptable to the authors. Any objection? Chair hears none. The amendment is adopted. Chair recognizes Ms. Click to close on the bill.
Thank you, Mr. Speaker. Members, I move passage.
Question occurs on passage to engrossment of House Bill 3240. All those in favor say aye. All those opposed say nay. Ayes have it. House Bill 3240 is passed to engrossment. Chair lays out on second reading House Bill 1447. Clerk, read the bill.
HB 1447 by Minhaj relating to the use of remote technology when conducting probate or guardianship proceedings.
Chair recognizes Ms. Minhaj to explain the bill.
Thank you, Mr. Speaker. Members, House Bill 1447 would allow probate and guardianship courts the option to use virtual remote technology for participants beyond the period covered in the emergency orders. I move passage.
Question occurs on passage to engrossment of House Bill 1447. All those in favor say aye. All those opposed say nay. Ayes have it. House Bill 1447 is passed to engrossment. Members, the next bill on the calendar is House Bill 2619. The Senate companion is over ineligible. The chair lays out on second reading Senate Bill 1118. The clerk read the bill.
SB 1118 by Johnson relating to the creation and administration of the on-the-ground conservation program by the State Soil and Water Conservation Board.
Chair recognizes Mr. Wilson to explain the bill.
Yeah, thank you, Mr. Speaker. Members, SB 1118 creates an on-the-ground conservation program that will help come flood season. Move passage.
Question occurs on passage to engrossment of Senate Bill 1118. All those in favor say aye. All those opposed say nay. The ayes have it. Senate Bill 1118 is passed to engrossment. Passed to third reading. Mr. Wilson moves to lay House Bill 2619 on the table, subject to call the chair. Is there any objection? Chair hears none. So ordered. Chair lays out on second reading House Bill 674. The clerk will read the bill.
Thank you, Mr. Speaker.
The clerk will read the bill.
HB 674 by Ramos relating to the informing the public about the availability of provisions and protective orders, including provisions regarding pets and other companion animals.
Chair recognizes Mr. Ramos to explain the bill.
Thank you, Mr. Speaker and members. HB 674 relates to informing the public about the availability of provisions and protective orders, including provisions regarding pets and other companion animals. I move passage.
Question occurs on passage to engrossment House Bill 674. All those in favor say aye. All those opposed say nay. The ayes have it. House Bill 674 is passed to engrossment. Chair lays out on second reading House Bill 2059. Clerk, read the bill.
HB 2059 by Busey relating to the date of runoff elections.
Chair recognizes Mr. Busey to explain the bill.
Thank you, Mr. Speaker. Members, House Bill 2059 would standardize the date of runoff elections for both May and November general elections. Mr. Speaker, I have an amendment.
Following amendment, the clerk read the amendment.
Amendment by Busey.
Chair recognizes Mr. Busey to explain the amendment.
Mr. Speaker, this amendment would simply change the date of a runoff election to occur on the sixth Saturday after the original general election for both May and November. This amendment is acceptable to the author.
Mr. Busey sends up an amendment. The amendment is acceptable to the author. Is there any objection? Chair is none. The amendment is adopted. Chair recognizes Mr. Busey to close on the bill.
Thank you, Mr. Speaker. I move passage.
Question occurs on passage to engrossment of House Bill 2059. All those in favor say aye. Those opposed say nay. Ayes have it. House Bill 2059 is passed to engrossment. Chair lays out on second reading House Bill 1802. Clerk will read the bill.
HB 1802 by Dominguez relating to a study evaluating the use of alternative therapies for treating certain mental health and other medical conditions.
Chair recognizes Mr. Dominguez to explain the bill.
Members, we lose about 6,000 veterans every year. And since 2001, we have lost 114,000 of our veterans to PTSD and suicide. What 1802 does is something that is sorely needed, and that's taking a fresh look at what we can do to save the lives of our servicemen and women that have given their lives to this country. What this bill does is it conducts the first of its kind study of alternative therapies in a controlled setting at the Baylor College of Medicine, working with the Houston Area Veterans Hospital, a very controlled setting to see if psychotropic medication, psychedelic medication will provide relief for those veterans most likely to commit suicide. This bill has been thoroughly vetted by top scientists and clearly with a heavy hitter standing to my side. This is a great bill. We hope that it will provide treatment for our veterans and save a number of lives. I believe that there is an amendment, and I will let Mr. Toth present that.
Following amendment, the clerk will read the amendment.
Amendment by Toth.
Chair recognizes Mr. Toth to explain the amendment.
Mr. Speaker and members, I want to thank the author of this bill for allowing me to speak on it, and I want to thank him for bringing it. As I've shared with many of you for the past 10 years, through Mighty Oaks, I've worked with veterans that have struggled with post-traumatic stress. And as he has shared in the one-page letter that you have on your desk, what we are doing to help veterans right now is not working. It's failing miserably. I gave you guys a one-page printout from the National Suicide Data Report that the Veterans Administration put out. And here's what it clearly says on page 41, and I'd encourage you to look at this. And what it states very clearly is that over an 11-year period, those veterans that are getting treated by the VA, not just diagnosed, but those that are getting treated by the VA have a 50 to 70% higher suicide rate than those that get diagnosed alone. We're not helping these guys, and why this bill is so critically important. We've got to uncover what we can do from a pharmacological standpoint to help these young men and women. If you go you'll also look at it, and you'll also find out there's another page in there that says that the highest incidences of suicide are among peacetime veterans. It's not from those that have served overseas and have seen combat. This bill is critically important, and we're not going to get it all done in this session with this one bill. We've got to come back next session. We have to start looking at the psychotropic medications that we're prescribing to our veterans that have failed us. And if you speak with most of the young men and women that are being treated by the VA, they're on a cocktail that's anywhere between 13 and 30 different prescriptions that they're on. We're harming them. We're not helping them. Bill Chatfield, who used to travel with Governor Perry, stated, Steve, the problem is that when these young men get off the plane from Iraq or Afghanistan, they lose their sense of mission, they lose their sense of purpose, unit cohesion in a job, they experience a little bit of depression, and the VA puts them on psychotropic meds, which separates them from the limbic system of their brain, and it's then they contemplate suicide. We are not helping our veterans, we're hurting them. This bill is critically important, and I ask for you to support it, but I am not going to hold my amendment on this bill because I think it would put the bill in danger. Thanks for your support.
The amendment is withdrawn. Chair recognizes Mr. Dominguez to close on the bill.
Members, with this bill, we can make a difference and we can send a message to Washington that they need to be doing more. So as usual, let Texas lead the way and please support this bill. Move passage.
The question occurs on passage to engrossment of House Bill 1802. All those in favor say aye. All those opposed say nay. The ayes have it. House Bill 1802 is passed to engrossment. Chair lays out on second reading House Bill 1090. Clerk will read the bill.
HB 1090 by bail is relating to the appraisal for ad valorem tax purposes of a property that was erroneously omitted from an appraisal roll in a previous year.
Chair recognizes Mr. Bales to explain the bill.
Speaker, members, currently chief appraisers may go back up to 5 years on the appraisal roll if they find that taxable real property was erroneously omitted. House Bill 1090 allows for back tax assessments on real property to only go back 3 years rather than the currently allowed 5 years. This would align with Section 25.18 of the tax code, which requires reappraisal every 3 years. Mr. Speaker, members, I move passage.
The question occurs on passing engrossment HB 1090. All in favor say aye. Opposed say nay. The ayes have it. HB 1090 passed engrossment. Is Ms. Gervin Hawkins on the floor of the House? The chair lays out on second reading HB 3610. The clerk will read the bill.
HB 3610 by Gervin Hawkins relating to the applicability of certain laws to open enrollment charter schools.
The chair recognizes Mr. Gervin Hawkins for a motion.
Mr. Speaker, I move to postpone House Bill 3610 to 10 a.m. tomorrow morning, Thursday, May 6th.
Members, you heard the motion. The objection, the chair hears none. The motion is adopted. The chair lays out on second reading HB 2306. The clerk will read the bill.
HB 2306 by Fierro relating to the denial of registration of a motor vehicle based on certain information provided by the county to the Texas Department of Motor Vehicles.
The chair recognizes Mr. Fierro to explain the bill.
Thank you, Mr. Speaker. Members, House Bill 2306 simply closes a loophole to ensure an information sharing agreement with DMV. Just to make it clear, this is current law. It's closing a loophole. With that, Mr. Speaker, I move the passage.
The question occurs on passing engrossment HB 2306. All in favor say aye. All opposed say nay. The ayes have it. HB 2306 passed engrossment. The chair lays out on second reading HB 2375. The clerk will read the bill.
HB 2375 by A. Johnson and Parrish relating to meals provided to jurors during deliberation of a civil case in certain district courts.
The chair recognizes Ms. Johnson of Harris County to explain the bill.
Mr. Speaker, members, what this bill does is correct what I would think is an error currently in the law that was passed in 1977 that says that our counties can only pay $3 for a juror's lunch. We are changing it to say that the counties can pick a reasonable amount. Again, this is payment by the county, and I move passage.
The following amendment, the clerk will read the amendment.
Amendment by Kaysen.
The chair recognizes Mr. Kaysen to explain the amendment.
Thank you, Mr. Speaker. Members, this bill eliminates the $3 cap on how much may be spent on lunch for jurors. The wording of the bill states that a judge may spend a reasonable amount. However, what's reasonable to one person may be unreasonable to another. When it comes to tax dollars, we shouldn't leave spending up to subjective language. My amendment would simply increase the current cap on jury lunches from $3 to $12. This would provide enough funds to purchase lunch for jurors while also maintaining a limit. Mr. Speaker, I move for adoption.
The chair recognizes Mr. Leach to speak in opposition to the amendment.
Thank you, Mr. Speaker. Members, I think this is the last bill for the night, so I'm going to make this very quick. Members, I want to encourage you to vote against this amendment. Our committee voted unanimously. The Judiciary and Civil Jurisprudence Committee voted unanimously for this bill. This allows our locals flexibility to provide reimbursements for our jurors. This is the first I'm seeing or hearing about this amendment. I actually believe that this will end up costing more. Setting a $12 limit cap will basically give our locals freedom to spend $12 per juror for reimbursements, and that is not the intent of the bill. And so, members, I want to ask you to resoundingly reject this amendment. It is not in the interest of taxpayers, and it is not in the interest of justice. Thank you, members.
The chair recognizes Mr. Kaysen to close on the amendment.
Thank you, Mr. Speaker. Again, what's reasonable to one person may not be reasonable to another. With no cap being set, I'm afraid that it's open season. So I would ask you to support this amendment, and I move for adoption.
The question occurs in adoption of the amendment. Mr. Kaysen has requested a record to vote. The clerk will ring the bell. Please show Mr. Leach voting no, Ms. Johnson of Harris voting no, Mr. Kaysen voting aye, Mr. Smith voting nay. All members voting. There being 13 ayes, 129 nays, the amendment fails to adopt. The chair recognizes Mrs. Johnson to close on the bill.
Move passage.
The question occurs on passing the engrossment of HB 2375. All in favor say aye. Opposed say nay. The ayes have it. HB 2375 passing engrossment. Members, the speaker's desk is clear. If you have any announcements, please bring them down front. Members, we have a very short list of bill referrals. Following bills and resolutions on first reading and referral, the clerk will read the bills and resolutions.
SB 225 by Paxton relating to the regulation of certain child care facilities and family homes referred to the Committee on Human Services. SB 504 by Miles relating to the authority of certain county fire marshals to inspect group homes, authorizing a fee, creating a criminal offense referred to the Committee on County Affairs. SB 741 by Birdwell relating to the carrying or storage of a handgun by a school marshal referred to the Committee on Homeland Security and Public Safety. SB 838 by Cold Course relating to the authorization by a school district or open enrollment charter school for a person to carry or possess a weapon on school premises for purposes of safety and security referred to the Committee on Homeland Security and Public Safety. SB 1109 by West relating to requiring public schools to provide instruction and materials and adopt policies relating to the prevention of child abuse, family violence, and dating violence referred to the Committee on Public Education. SB 1149 by Cold Course relating to the transition of case management for children and pregnant women program services and Healthy Texas Women program services to a managed care program referred to the Committee on Human Services. SB 1191 by Seliger relating to the definition of a school resource officer referred to the Committee on Public Education. SB 1353 by Miles relating to the content of certain immunization records and of certain biennial legislative reports on immunizations issued by the Department of State Health Services referred to the Committee on Public Health. SB 1616 by Betancourt relating to powers and duties of governmental entities during a public health disaster providing civil penalties referred to the Committee on Public Health. SB 1716 by Taylor relating to supplemental special education services and instructional materials program for certain public school students receiving special education services referred to the Committee on Public Education. SB 1744 by Zaffarini relating to the services provided by Colonia Self-Help Center referred to the Committee on Urban Affairs. SB 1772 by Zaffarini relating to the establishment of the Texas Pollinator Smart Program for solar energy sites referred to the Committee on Agriculture and Livestock. SB 1921 by Lucio relating to Medicaid reimbursement for the provision of certain behavioral health and physical health services referred to the Committee on Human Services. SB 1941 by Gutierrez relating to a strategic plan to address hyperemesis gravidarum referred to the Committee on Public Health. SB 1942 by Gutierrez relating to the creation of public health facility corporations requirements applicable to public health corporations referred to the Committee on Urban Affairs. SB 2195 by Colcourse relating to the relationship between pharmacists and pharmacies and pharmacy benefit managers or health benefit plan issuers referred to the Committee on Insurance.
Mr. Murphy moves the House adjourn until 10 a.m. Thursday in memory of Carmel Bittendyer, MD, renowned geriatrician and family friend. Is there objection? The chair hears none. The House stands adjourned.